The following recording was recorded at the College of Law on November 13th, 2021. The subject under discussion for this symposium was direct democracy from theory to practice, and the impetus for the conference was two Nebraska Supreme Court cases that were decided in November 2020. The program proceeds through a series of panels, and those panels are marked within the video with frames that show each panel. The first panel progresses along the lines of theoretical perspectives on direct democracy in the United States. That has Miriam Seifter as well as Robinson Woodward Burns. The second panel is a set of speakers who are talking about the substance of direct democracy provisions, that is, how we execute some of the policy and reflect the theoretical underpinnings of these provisions. This focuses in a little bit on the single subject rule, which is one of the substantive rules associated with direct democracy in Nebraska, as well as many other states. That panel includes Richard Briffault, who's written about the single subject rule in the legislative context, John Dinan, as well as Jonathan Marshfield. The third panel proceeds from substance to process, which is really sort of the who decides part of direct democracy substantive rule implementation. And so the who decides part was discussed by Judge Jeff Sutton from the Sixth Circuit U.S. Court of Appeals, who talked really from the sort of judicial perspective, and then Anthony Johnstone, who spoke about his experience working in state government as well as his academic expertise on the who decides piece of doctrinal implementation when it comes to single subject rules. The final panel, the fourth panel in our discussion, was a roundtable of Nebraska stakeholders or practitioners, I guess. So there were three individuals on that panel: Wayne Benna with the Secretary of State's office, Andy Berry, who's a private practitioner here in Lincoln, Nebraska, who does a lot of advising groups. And then the final panelist on that last panel was Adam Moorfeld, who's a state senator here in Nebraska, who's comes at it from both the legislative perspective as well as the stakeholder perspective, in that he's helped shepherd a number of initiative petitions over the past few years. So those are the four panels. They're marked in the video with panes, so you can scroll through the video and see where they start and where the prior panel ends. Jonathan Marshfield at the University of Nebraska College of Law was my co-creator on this project, and so he deserves a lot of credit. Steve Wilborn and Bob Evnen. Steve Wilborn's on our faculty. Bob Evnen is the Nebraska Secretary of State. They had the original idea for this symposium and sort of brought it to us to execute. They had that idea back in November 2020, and it was a good idea. Other folks that have helped us a great deal in putting on this symposium: the College of Law, of course, and Dean Richard Moberly, who holds the purse strings and enables us to do things like this. Katie Fanasteel, who provided help on registration, logistics, CLE, that sort of thing. Amber Ediger, who helped with website marketing and planning. Alex Lenhard, who helped with scheduling, food, and setting up the program. My daughter Berlin even helped let people in the door at the symposium. Another debt of gratitude is owed to Peter Longo and Bob Mewald, who wrote a book on the Nebraska Constitution, The Nebraska Constitution, a Reference Guide. That book's first edition was in 1993 with Greenwood Press, and Peter was kind enough to bring me into the fold in 2009 when we did a second edition with the University of Nebraska Press. That's the Nebraska Constitutional Reference Guide. That book is basically the only modern work that's really tending to the Nebraska Constitution, and it stands on the shoulders of important authors like Addison Sheldon and James Olson. So the reason I mention that sort of at the tail end of the thank yous is that it's a reflection of how important scholarship is with regard to this subject. The work of scholars is an important part of the watchfulness in the citizens that's the inscription on our state capitol's entrance, which declares that that's where the salvation of the state lies. That important thread of citizen involvement in our constitutional order and our governance structures is the provision that we discussed at the symposium. And those provisions provide the citizens with the power to overturn the work of those who are supposed to speak for us. They provide us with limits in our constitutional text on those we empower, and they give the citizens themselves the power to pass laws that don't seem to make it through the legislative process for one reason or another. that power that the people wield is an incentive for them to engage in government. And without that engagement, the watchfulness of the citizens, without that engagement, civil society and the rule of law run the risk of faltering at the hands of the disorganized and those with unprincipled judgments. So thank you for taking the time to be a part of this symposium, even if you're consuming it after the fact. And thank you to our panelists. It's important work, and I hope you're happy to be a part of it. My email is included at the end of the proceedings. It's anthony@unl.edu. If you have any thoughts, questions, concerns, or want to be a part of this overall project, trying to reform and think about Nebraska's constitutional provisions on direct democracy, by all means shoot me an email, and there may be opportunities that exist. So thank you and enjoy.
Well, thank you so much for inviting me to join you today. I'm really looking forward to the conversations we'll have, though I wish I could have come to Lincoln in person. And I'm especially excited to learn from your experiences with direct democracy and to hear how they do or maybe don't align with the reflections I'll offer today. So I've been asked to offer some framing remarks on this theory panel about how direct democracy or ballot initiatives fit into the bigger picture of American democracy and or American constitutionalism. And since I'm going first, I thought I'd start with a sort of 10,000-foot view and orient my remarks around three questions that I think tend to be recurring ones when we talk about direct democracy. So the first question is, how do ballot initiatives fit into American state constitutionalism? And here I'll talk about how direct democracy, I think, fits actually very neatly into the state constitutional embrace of what I have called the democracy principle. Second question I'll talk about is, how do ballot initiatives fit into the national picture? And here I'll emphasize ways that ballot initiatives today are important, not just for state level majorities who aren't otherwise being heeded, which I think is how we often think about them, but also to national majorities who find themselves shut out of national institutions. As I'll discuss, that might, sort of always be a possibility, but there are today a combination of political and structural factors that make it harder for majorities to rule at the national level, and ballot initiatives may be offering them an alternative channel. And I think it's not a coincidence that around the country, there have been hundreds of bills in the past couple of years proposing to limit ballot initiatives in various ways. I think we can understand that as partly a response, not just to their state role, but to their important national role. And then the third point I'll talk about is a normative one. And I'll discuss one common critique of direct democracy, which is that it may allow the majority to go too far, to oppress some minority group or interest. And in response to that important critique, I'll propose a sort of framework for thinking about those arguments and tie them to the attacks on direct democracy today. To the extent that I have any bottom line to offer, I think it is a qualified defense of direct democracy. It's qualified because direct democracy, like so many other things, is imperfect and it can surely go awry. But right now we have a shortage of opportunities for majority rule in the United States, and direct democracy creates that opportunity. Not a guarantee, but an opportunity for majorities to prevail. And I think, as I'll talk about, the current attacks on the institution of direct democracy tend not to reflect some of the classic circumstances for constraining it. So before I dive into the first point, I did want to mention one other framing point, which actually echoes something that Anthony was just talking about. And that is that I really want to commend and thank you for choosing to organize this symposium. I think that, as Judge Sutton mentioned in his talk yesterday, too often we, at least as legal scholars, ignore state constitutions and state institutions in favor of their more famous or more glamorous federal counterparts. But that's a mistake with real consequences. For state constitutions to do anything useful, as Anthony just said, they really have to be taken up by people, legal communities, who pay attention to them, who discuss them, figure out their meaning, invoke them in and outside of courts. In other work, I've referred to this as a constitutional community. A functioning constitutional community needs a whole range of types of members, from judges to litigants to academics to journalists and more. On the other hand, when no one is paying attention, I think there arise opportunities for ill-advised or even anti-democratic or opportunistic behavior. I personally am involved in this effort. I've launched a new research initiative at Wisconsin this year with the idea of trying to promote and focus more on state public law and bring people together to have convenings sort of like this one. So I think that by organizing this conference, you're really doing a great service, and I'm happy to be part of it. So without further ado, let's talk about direct democracy and state constitutions. So how does direct democracy fit in with American state constitutionalism? And my answer here is that direct democracy looks like an oddball from the perspective of the federal constitution, but is really right at home in the spirit of state constitutions. Scholars often discuss constitutionalism as sort of, a theoretical idea as something that's in tension. And the federal constitution, if that's your point of reference, does exemplify that tension in a lot of ways. Drafters of the US Constitution were alarmed by what they saw as the, quote, majoritarian tyranny in the states. They were worried about the so-called excesses of democracy, and they were determined to create a document that would avoid those perceived ills. As Michael Klarman has written in his book, The Framers' Coup, quote, despite the framers' regular professions of devotion to popular sovereignty, their deep distrust of the people was evident in nearly every substantive choice made in the Constitution that bore on the federal government's susceptibility to popular influence. And it's because of those choices that legal scholars and political scientists today document how the design of the federal Constitution tends to give a smaller role to popular majorities. Sandy Levinson has prominently written in his book, Our Undemocratic Constitution, that, quote, none of the great institutions of American politics can plausibly claim to speak for the majority of Americans. So if you're thinking about the federal constitution as your point of reference, it might seem like constitutionalism and a direct voice for the people are two concepts that really don't go together. But state constitutions, as I think folks in this room know quite well, are different, at least in their basic design. Indeed, it's possible to think of state and federal constitutions as having different, opposing, and even complementary focuses, with the federal constitution protecting against the problem of too much majority rule, and the state constitutions protecting against the problem of too little of it, or in other words, the problem of minority faction. So I thought I'd mention an article I've written about this recently that maybe brings some of these points together. It's an article I co-authored with Jessica Bowman-Posen in the Michigan Law Review. And our argument is that state constitutions, unlike the federal constitution, do expressly and repeatedly espouse democracy as a core value. And so I'm a little bit hesitant with a group of state constitutional scholars to belabor this point, because maybe it's already right there for you, but I thought I would just go through some of the provisions that state constitutions include, which I think ultimately overwhelm in their embrace of democracy, at least if you have, again, the federal constitution as your reference point. So first, popular sovereignty. 49 out of 50 states include an express commitment to popular sovereignty in their state constitution, often formulated as something like, all political power is inherent in the people. Similarly, every state constitution confers the right to vote, and in addition, a large number of states go further. So for example, 26 states have additional provisions that say things like elections should be free or free and equal or free and open. And then we can think about elected officials. In the executive branch, state constitutions favor elected offices filled by statewide popular votes with no electoral college equivalent. And that includes not just the governor and lieutenant governor, but a plural executive, in which a whole range of other officials are also elected in that manner, like attorneys general, secretaries of state, treasurers, auditors, controllers, and superintendents. And then, as yesterday's lecture brought up, there are judicial elections in a majority of states. And most of those, too, are elected without any districts. You can also think about the democracy principle as being evidenced through legislative structure. State constitutions, as we know, provide for apportioning legislative districts by population for both houses of the legislature. In other words, it's not just that there's no electoral college, there's also no Senate. And that's, of course, in part thanks to Reynolds versus Sims. And so we could have a longer conversation about the sort of dialogue and complementarity of the federal and state constitutions. Could also think about the democracy principle as informing accountability of the legislative branch. State constitutions contain a whole range of accountability related mechanisms that are intended to keep legislators responsive to the public and facilitate public monitoring of their work. Things like single subject rules, which I think will come up in a different context today, multiple reading requirements, proceedings being open to the public, and more. There are also substantive constraints on minority rule. So state constitutions generally include things like prohibitions on special legislation or requirements that all legislation serve a public purpose. And then finally, there's our focus today of direct democracy in almost half the states, some as a way of passing constitutional amendments, some as a statutory mechanism, some both. Most of these states also have the referendum, and many also have recalls of elected officials. And that's part of the reason, although not the only mechanism, that state constitutions are also finally so much easier to amend than the federal constitution. So that's sort of like a quick tour of some of the textual evidence of this state commitment to democracy. And from this extensive text, and for historical reasons that we describe further in our paper, we identify this state democracy principle that's committed to three pillars. One is popular sovereignty, as seen in provisions like Declaration of Popular Political Power, the power of amendment, and the insistence that the people, not just the legislature, must be the continual author of government decisions. Second pillar is majority rule, which will be important to our conversation today, as seen in provisions like the widespread majority vote style of elections without mediating institutions like the Electoral College and Senate, and of course, our topic, the initiative. And then also importantly, as I'll be coming back to, the pillar of political equality, as seen in provisions like the public purpose clauses, distinctive guarantees for equal protection, the insistence on free and equal elections, and more. So the takeaway from this first point is that while the idea of direct democracy may seem at odds with our form of federal constitutionalism and its relationship to democracy, it's really well aligned with state constitutional thinking. And as I'll discuss in the next part of my talk, it's partly because the federal constitution leaves such little space for majority rule that ballot initiatives are playing an especially important and I think especially scrutinized role right now. So that was part one. Let's turn now to this idea that state constitutions and their direct democracy provisions also are sort of national pathways. And I think again that this partly explains part of the, I think, surging interest in direct democracy and surging interest in reforming and constraining it. So my observation here is that right now, direct democracy is playing an important role in our national small d democratic politics. And I think to set this up, it might be helpful to bring in some observations from a different literature, one that one would hope was not growing as much as it is, but it's the literature on democratic decline. So scholars who are concerned about the sort of erosion of democracy today have highlighted this pressing problem, and that is that democracy requires majority rule, and theorists have complicated that idea endlessly, but it is typically a necessary, if not sufficient, condition for democracy, right? Political equality, for example, I'll talk about, is also required, but democracy does require majority rule. And yet a combination of factors have made it really difficult for majorities to rule at the national level in our present political era. These factors include political geography, which speaks to the idea of how Republicans and Democrats are distributed or not distributed evenly in rural areas versus urban ones. Another factor is political polarization and sorting, which political scientists say is at an extremely high level, which speaks to how Republicans and Democrats seldom have ideological overlap today, but instead are kind of sorted into two separate parties that align with not just their votes, but their ideology and values. And then the structure of our national institutions, which as already mentioned, are not structured to favor majorities and entail a tilt in favor of rural areas. So the democratic decline scholars would say, put those factors together and you get a situation in which parties and positions that have majority support may be unable to prevail. As Steve Levitsky, the co-author of How Democracies Die, recently noted, we're approaching this concerning period in which it seems like a minority party could plausibly wield control of all national institutions. So in other words, the idea of this literature isn't that majority rule is perfect, far from it, but rather the concern is that we could be entering a period of entrenched minority rule in which democracy would cease to be a true competitive democracy. Okay, so back to our topic of state con law. What could a determined majority do to solve this problem? Well, many scholars of the sort of national system would say that it would take big changes to our federal institutions, like reforming the Senate would be a prominent example. But of course, that's not very politically practical, right? It would not only is the well, it would entail a whole host of problems, including self-sacrifice by those in power, and then all of the complications that go with actually amending the Constitution. So in contrast, state institutions, including direct democracy, provide what I refer to as constitutional opportunities for national majorities. By constitutional opportunity, I just mean to refer to a group's prospects of wielding power. We're already familiar with the idea that direct democracy can provide constitutional opportunities for state-level majorities to rule when their interests are not being adequately represented in the state legislature, right? That's the kind of classic take on what direct democracy does. It gives the people an option other than the legislature for making law if the legislature isn't serving them. And we might think of sort of, archetypal state experiences like states that have tried with reform like South Dakota, or the various states that have used direct democracy to advance independent redistricting when their legislatures wouldn't. Those, I think, are classic examples of direct democracy creating constitutional opportunity for state-level majorities. So what I'm suggesting here is the idea that direct democracy today might also provide the opportunity for state-level majorities who are also national majorities to have their way, right? An example here might be things like expanding Medicaid or raising the minimum wage. By creating this majoritarian pathway, states with direct democracy give these nationally pervasive but stymied views a potential outlet. And again, I think this also helps to explain the raft of attacks against direct democracy, not isolated within a few states, but across the country. So my second point is just that because of this contingent political and social set of factors we encounter today, we should understand direct democracy as not only having significance for state governance, which is itself very important, but also for national governance. Before I move on to my last point, I just wanted to add two caveats about the idea of direct democracy as a pathway for national majorities. The first point is to notice how contingent it is. And a hat tip here to Richard Buffalt, who I know is speaking later, with whom I had a helpful prior symposium conversation about this. The point is contingent in the sense that the conditions that make majority rule difficult at the national level are not absolutely fixed, right? They're functions of factors that I mentioned, like political geography and political polarization and sorting. And those factors haven't always been true, and perhaps they will not always be true. And if national majorities have easier paths to ruling nationally, the initiative might become less critical to them. Still of interest, but not a place they turn with sort of full energy. Second caveat, or sort of additional point to mention about this, is just that I want to emphasize that the constitutional opportunity for ballot initiatives to facilitate majority rule is just that, right? Just an opportunity. Depending on the design of the process and other circumstances, any given ballot initiative might not reflect the majority will. And I'm sure many people here can think of an example that they think fits that, right? Maybe it's because the title or the description was confusing, maybe turnout was very low, maybe advertising created a misimpression, and so on. So I think an important challenge for ballot initiatives, and one that I'm really interested in hearing more thoughts on, is how to make them live up to that opportunity and that promise. Okay, I promise I'm at my third point, and this is a short one. And this is just that I want to offer some thoughts on the critiques of direct democracy. And here my ideas are somewhat preliminary, and they draw from a working paper. But the critiques I have in mind are those that say, we really need to rein in direct democracy today because of its potential to oppress minority interests. I think this critique gets traction because it implicates justifiable ambivalence about majority rule in the American tradition, and indeed just in constitutional theory more broadly. Right? We know that majorities can indeed do harm. And indeed, we know that in part because we know that political equality is another important pillar of democracy. But we also know that we value majority rule, and that it's particularly important today when it might be in short supply, both nationally and in some state legislatures, as I think we discussed in the Q&A yesterday. So how do we separate the wheat from the chaff here, right? How do we avoid just kind of endless spinning in circles about whether democracy, direct democracy is good or ill? And how do we separate serious critiques that really need attention and call for reform from more spurious ones? So I want to propose a kind of organizing framework just to sort of help us arrange our thoughts and then illustrate it with a recent case from the Idaho Supreme Court, and then turn it over to Robinson. The framework is just to think that all efforts to constrain majority rule can be organized along two continuums. One continuum is how severely we constrain the majority, right? Is it strong medicine or soft medicine? And we can break that down further into constraints that are outcome determinative or merely influential, constraints that are specific to one issue or that apply generally, and constraints that are time limited or that are durable. So that's the first continuum. And then the other is, what is the seriousness of the problem that justifies the majority constraint, right? In the legal literature, if we're thinking about process theory and John Hart Ely, we might think about the two kind of classic problems that require constraining a majority as being the problem of entrenchment, in which a majority tries to cut off political competition and cement itself in power, and the problem of discrimination, right? When the majority does not treat minority interests or groups fairly and equally. Beyond the classic severe problems, there are other reasons to constrain majorities, but we might think of those as sort of smaller problems or less severe ones, right? They might be the kind of thing that's actually applicable to any decision making. Like, we would like to encumber the decision making process enough that we can believe it's deliberative and not made rashly. Okay, so where am I going with all this? Well, a simple framework for evaluating critiques on majority rule is just that the strength of the mechanism should probably generally correlate with the severity of the underlying problem, right? If there is entrenchment or discrimination afoot, a more significant burden on majority prerogative might be needed. But if there isn't, if we just have a sort of general concern that direct democracy can be misused, we should do things to improve it that don't go so far as shutting the majority down. So final thing I'll do is to illustrate this with a recent case from Idaho, which I think made this point better than I am. And the backstory is Idaho's approval of Medicaid by ballot initiative in 2018, after which the Idaho legislature went about making it harder for ballot initiatives to pass. As the court ultimately noted, Idaho wasn't a state with easy rules or evidence of abusive process to begin with. And I think in the 8 years prior to the case, 14 petitions had been circulated and only 2 had qualified for the ballot. So fast forward to the case that was at bar, there was a new Idaho law, SB 1110, which had supposedly given Idaho the most stringent ballot initiative process in the country. It would have required the threshold number of signatures to be collected from all of the state's 35 legislative districts. And advocates said this would have made getting initiative on the ballot go from difficult to impossible. Now in court, SB 1110's proponents said this is necessary because we all know that majorities can trammel minority interests, right? Majority rule is a dangerous thing. Now in August of this past year, the Idaho Supreme Court struck down this law. And among other things, the court noted that the state constitution states that all political power is inherent in the people and that the people's reservation of legislative power to themselves is a fundamental right. It observed a, quote, unmistakable pattern by the legislature of constricting the people's initiative and referendum powers after they successfully use it. And on our specific question of when we need to constrain majorities, the court said this, show us some evidence of the kind of oppression of minority interests that you're worried about. Right, all you've shown us is that the voters used the ballot initiative to expand Medicaid, and we don't see evidence of minority oppression in that action. And absent that kind of indication that there is really a problem afoot, the court was not willing to sign on to this bill that would basically have made ballot initiatives impossible in the state. Now, the Idaho Supreme Court is not reading my work, but their opinion does exemplify both the democracy principle and a reasonable way to constrain it and apply it. Right, the democracy principle provides the strong foundation for direct democracy in the states that have it, and being open to evidence of its misuse is important, right? Because again, it could show infringement of the pillar of political equality, and the court worked this out by looking at evidence that was available to it. So, final thing, just to say in closing, direct democracy is emblematic of the state constitutional democracy principle, which prizes majority rule, political equality, and popular sovereignty. It's serving an especially important role today as an outlet for not just state level majorities, but thwarted national majorities, but is also receiving more scrutiny and attacks for that reason. And in analyzing those attacks and critiques, we should take care to see that the strength of the proposed reform is roughly commensurate with the problem that's being identified. So I will wrap up there. Thank you so much for listening, and I'm really looking forward to hearing from y'all.
Thank you, Miriam. I'll turn it over to Robinson.
Thank you, Anthony. I'd like to thank the conference organizers and attendees, and I'd also like to apologize for not being there in person, but I look forward to what promises to be an excellent discussion. So my aim today is to talk about how state constitutionalism broadly and how initiatives specifically vent pressure for national constitutional reform. This is an argument I think that is probably pretty similar to the one that Miriam just made, and I want to elaborate that a bit in detail. So we know that state initiatives were designed to and can be used to circumvent non-compliant state legislators. We also know that state constitutional reform can be used when federal constitutional reform is unavailable or difficult. And what I want to do is try to draw together these two arguments to show how state constitutional initiatives specifically can be used to resolve national constitutional controversies, and especially to circumvent non-compliant congressional legislators. That is to say, while state constitutional initiatives were designed to circumvent or constrain state legislators, an unanticipated consequence of this design over time has been that reformers and social movements have opportunistically looked to the state constitutional initiative to achieve the kinds of national change that they see stymied in Congress. So I'll elaborate this in 3 steps. I will briefly outline essentially the theory of this, how I see this working, and put it in dialogue with some existing perspectives on the state initiative process. Then I'll give a pair of case studies, which I think elaborate what this looks like in process. And I intend these sort of as illustrative stories to, again, sort of give some detail or heft to my claims. And then I'll conclude with a few lessons about what this might mean more broadly for national political change. So I'll briefly recap first how state constitutional initiatives at least are supposed to work. Conceptually, these direct democracy provisions were designed to constrain elite actors and especially to constrain state legislators. Between 1898 and 1918, 18 states, mainly in the West and the Midwest, empowered voters to bind their legislators by initiative. And we see these being instituted in states where parties are newer, where they're weaker, in places where legislators see the state electorate as more likely to hold their policy positions over time. And effectively, these measures are instituted by legislators so that these voters can constrain future legislators who might not hold the policy positions that current legislators want. So again, there's this concept similar to the one Jan Elster uses of a constitution as being self-constraint, much like that of Ulysses at the mast. Now, parallel to this, there's an argument that state constitutions can vent pressure for national constitutional reform. Progressives made this argument. Lord Bryce, in his 1888 work, The American Commonwealth, viewed state constitutions as sites of experiments. And famously in 1932, Justice Brandeis made that same laboratories of democracy argument. One thing I tried to do in my recent book, Hidden Laws, How State Constitutions Stabilize American Politics, is to give an empirical account or test of whether this has in fact happened. And so what the book does is it builds 2 large and parallel data sets, one of attempts at federal constitutional reform, another at attempts at state constitutional reform. I look at attempted federal amendments, state amendments, and also attempts to write new state constitutions. And we find that on average, there is strong, positive, and statistically significant evidence that attempted federal amendment and attempted state amendment are associated over time, and that attempted federal amendment and attempted state constitutional replacement are also associated over time. That is to say, it's very unlikely that there is no correlation between attempts at national and state constitutional reform. What the book does, though, is it breaks down this pattern from the founding era to the present and sort of elaborates how this works through a series of case studies showing that reformers blocked by Congress or the federal courts will use state constitutions to entrench the policy provisions that they'd like. And this sort of makes sense. The federal constitution is famously the hardest national constitution in the world to amend in that it sets the highest barriers to constitutional reform. 2/3 of both houses of Congress, or a convention called by 2/3 of the states, must first pass an amendment, which then has to be ratified by 3/4 of the state legislatures and convention, or state legislatures, or states meeting in convention. And that is often prohibitively high. Of the 11,969 proposed federal amendments I code, only 27 have passed, and only 17 since the framing of the Bill of Rights. So reasonably, we might expect social movements and reformers to look to the state level, where famously the barriers to amendment are in all states lower, in which states in which there are a host of direct democracy provisions, recalls, referenda, and initiatives, and in which the states also offer alternate means beyond amendment to constitutional reform, including wholesale replacement by convention, commission, and sometimes by legislature. So I think that this broad pattern can also be applied to the state constitutional initiative process. If it's the case that reformers will take that path of least resistance and look to state constitutional reform in lieu of federal reform, then it should be especially likely that we would see reformers turning to the initiative process, which ought to be easier to pass, especially when state legislators, like their congressional counterparts, are hostile to reform. We would expect in moments where Congress is especially polarized, or where Congress has very narrow lawmaking majorities or partisan majorities, that the Article 5 path to formal amendment, or even to significant statutory reform, would be closed. When Congress is unable to form the very large majorities necessary for constitutional change, we would see this venting process, reformers turning to the state level, to be even more likely. And so that's sort of one expectation I have, is basically the Article 5 process incentivizes people to look to the state level, especially to the state initiative process, and especially when Congress is polarized or has very narrow majorities. And that kind of deadlock and hyperpolarization defines the current era. So one thing we might expect to see is, again, as Congress now is increasingly deadlocked, that reformers would look to state constitutional reform as an alternate venue for attempting constitutional reform. So what I'll do now is I'll give a pair of examples which I think kind of illustrate how this pattern has worked historically. I'll try to demonstrate how reformers blocked in Congress have looked instead to the state constitutional initiative process to entrench their policy aims. The first case deals with the direct election of United States senators, and the second case deals with fiscal reform, balanced budget reform, and tax reform. The first case comes from the late 19th and early 20th centuries, and the second from the late 20th century. So the direct election of United States senators provided for, eventually through federal constitutional amendment, the path to federal amendment, that was very difficult. State legislatures, prior to the passage of the federal direct election, senatorial election amendment, state legislatures picked their United States senators, their nominees for the United States Senate. And this was a particularly contentious process. State legislatures deadlocked regularly on party lines in the selection of United States senators. Between 1891 and 1905, there were 46 cases of state legislative deadlock. Occasionally, in cases of ties, you would see bribery breaking ties, which brought about 10 Senate investigations and several resignations of United States senators. And then occasionally, even when bribery, in cases where bribery was unable to resolve deadlocks, you would get split legislatures unable to pick a senator at all. In the 1890s, there were 9 cases in which state legislatures failed to fill Senate vacancies. The United States Senate was, between 1893 and 1907, the United States Senate was fully seated only for the 1903 to 05 session. And so there was this broad consensus among academics, among progressive academics, that this method of legislative selection was effectively, it stymied the selection, it blocked the selection of US senators, as the progressive scholar George H. Haynes said there is, quote, never a long contest over a senatorial election which does not do some serious harms to the interest of the Commonwealth. As a result, there were a number of federal congressional amendments proposed for direct election of United States senators, and several passed the House. Direct senatorial elections passed the House of Representatives in 1893, 94, 98, 1900, and 1902. The 1900 amendment, for example, passed the United States House 242 to 15, but it never received a Senate vote, dying in the Senate Committee on Privileges and Elections. United States senators who'd been selected through the legislative process, the state legislative process, had no stakes in overturning the process, which secured their election and their re-election. And so what you get is basically circumvention. The progressive academics who favor direct election, as well as members of the Populist Party and self-identified progressives, start to look to the state level. And in response to the failure of federal amendments between 1890 and 1912, you see a host of states pushing for direct election of senators. 29 states allow direct election of senators, but the difficulty is that these are often non-binding advisory elections in which the electorate picks their preferred candidate, but these elections don't bind state legislators to pick the popularly elected candidate. So, for example, in Nebraska, we actually see the advent of this system under the 1875 Constitution, which includes a provision letting the legislature call non-binding popular elections for senators. Now, in practice, this is not initially a functional system. Counties rarely place Senate election candidates on the ballot, turnout is low, and state legislators ultimately decide to ignore the results. While Nebraska has a very strong, again, Williams, Jennings, Bryan style populist tradition, ultimately this early Nebraska attempt at direct election is more a rhetorical sort of appeasement of the voters. Legislators never constitutionally bind themselves to these direct elections. You see a similar move in Nebraska in 1899, requiring ballots to include Senate candidates, but these are non-binding as well. Now, ultimately, a tool does emerge to bind state legislators to accept the outcome of the popular vote, and that's the state constitutional initiative. Parallel to the institution of direct election of U.S. senator votes for the direct election of U.S. senators, you see state constitutional initiatives emerging. 13 of them emerged between 1898 and 1912. 13 states institute that, and that 1912 date is significant because that's finally when the 17th Amendment for direct U.S. senator elections passed. So ultimately, it's Oregon that merges direct election, sort of advisory elections for U.S. senators and this constitutional initiative mechanism, using the constitutional initiative to bind their state legislators to accept the advisory elections that voters are holding. Oregon, it looks a lot like other states in that it has this problem of deadlock in selecting its U.S. senatorial nominees. So in 1895 and 1897, the state legislature deadlocks, it fails to select a candidate. The governor, Theodore Geer, tells the legislators to, quote, obey the general demand from the people and the press of the state in selecting the popularly selected U.S. Senate candidate. But legislators ultimately ignore Geer. Governor Geer, they ignore the advisory vote held by their state electorate, and they pick an alternate candidate in the 1901 election after a 5-week deadlock. Following this, in 1904, voters invoke the state constitution and they pass an initiative requiring that legislators publicly pledge to accept the results of the next popular vote for the United States senator. And they circulate rather an accompanying petition promising to oust any legislators who renege on this promise. Legislators, and it's mainly Republican legislators, could not statutorily block this constitutionally implemented citizen initiative, and so instead they choose to obey it. And ultimately, they select a candidate from the other party, a Democrat, who had been picked in the state in the advisory election. So it's this combination of initiatives which bind the constitutional initiatives used to bind legislators to accept the popular vote and the institution of the popular vote, which sort of together create a functional system in Oregon. It's called the Oregon system, and progressive scholars and policymakers look to this as an example to be imitated in other states. Woodrow Wilson, who was both a scholar and then later as governor of New Jersey, was a supporter of this plan. He recommends it to his state legislature, and he thinks that this is an effective way to vent pressure that's blocked in Congress. He says that the Oregon system is, quote, the way which the thing is virtually brought about without a federal constitutional amendment. Wilson sees the state initiatives in combination with these direct election provisions as a way of doing what Congress cannot do. Now, the Oregon system is partly imitated in several states. 13 states institute direct election and allow citizen initiative. Several use the initiative to expressly bind their state legislators to accept the outcome of the popular vote. In other states where that's not used, governors and legislators recognize that it could be used as it had been used in Oregon. It's the possibility of being bound by the state initiative that binds, that makes these legislators accept the outcome of the direct vote in senatorial elections. Now, ultimately, through this Oregon system and the diffusion of direct election of senators at the state level, you see that 30 states, by the time the 17th Amendment passes, have some direct senatorial election provision. And this changes the makeup of the United States Senate. The proportion of senators selected by direct election increases from 1/5 of the chamber in 1905 to 4/5 in 1909. You see a remarkable swift change. Ultimately, that change affects how senators behave. Now nearly all senators in the United States Senate rely on direct election for re-election, and so finally support the matching federal amendment for direct election in 1912 and 13. If an amendment passes the chamber in 1912 and is ratified the following year. So this gives some evidence that it might be a case that state constitutional initiatives can address pressures for national reform and resolve national controversies. I'll give one shorter example, and then I'll offer maybe a single concluding lesson. Another example concerns federal fiscal reform. So in the 1970s and 80s, there was significant pressure on Congress to pass fiscal reform measures. Between 1975 and 1979, 30 states petitioned Congress to pass a balanced budget amendment by calling an Article 5 proposing convention. And while many of these petitions were incorrectly filed, such that the number was probably a little short of the 30 that some scholars have proposed, it pointed to significant pressure and interest in a national constitutional amendment of some kind. When the Senate Judiciary Committee rejects some of these convention petitions as incorrectly filed, we see a host of amendments for fiscal reform instead called before Congress. Between 1980 and 1994, Congress proposed 272 balanced budget amendments, 103 appropriations amendments, 82 item veto amendments, and 45 amendments constraining the national debt. And some of these come close to passing. A balanced budget amendment cleared the House and failed in the Senate by only a single vote. Consistently, though, we don't see these amendments actually clearing. Again, one gets close, but that's 1 out of 400. Most of these amendments proposed before Congress fail. And so anti-tax reformers start to look to the state level. They're buoyed by significant populist support for repeal on taxes or reduction on taxes. And you see early balanced budget amendments in states like Illinois, in 1971, in Tennessee and Hawaii in 1979, and then we see that diffusing throughout the states from there. It's really in California, though, that the initiative system is used to constrain the legislature and constrain the legislature's spending, taxing, and borrowing powers. California passes Proposition 13 in 1979, which limits property taxes, real estate property taxes. This is seen as something of a popular revolt, especially among middle-class suburbanites. For this reason, it's called the tax revolt. And that's in 1978. In 1979, Californians passed Proposition 4, limiting state expenditures. The California example is widely imitated. Opinion polls suggest that in November of 1980 suggest that voters nationally have been following the California example. 3/4 of Americans outside of California knew about Proposition 13, and 2/3 of them supported similar tax reforms. In 1978, 17 states attempt tax reduction initiatives. By 1981, 43 states capped taxes. By 1984, 44 had called referenda for fiscal responsibility of some kind. And ultimately, in some cases, you see by the 90s a rollback of this. Colorado passes something called the Taxpayers' Bill of Rights in 1992. It's briefly worded rhetorically, it's very punchy. It refers to the rights of voters to constrain their legislature and forbids that legislators constitutionally increase state revenue over that of a previous year. But ultimately, we see gradually Coloradans dismantling this system by creating exemptions such that state legislators are better able to fund programs and public services like public education or K through 12 education. So ultimately, you see sort of a softening of some of this. The main point here, though, is that federal reform, which is sort of unable to clear these high Article 5 thresholds on tax issues, is ultimately achieved at the state level as a substitute, albeit a partial one, for attempts at federal reform. So to conclude, I think there's maybe one kind of significant lesson here, and that's this. If we only look at, say, federal constitutional amendment, if we only look at Congress's attempts to revise the federal constitution, then we might say that we might have a model or a story in which pressure for national reform emerges. Members of Congress sort of address this, gradually considering the prospects or sort of the deliberating on the necessity of a federal amendment, and then ultimately decide to pass or not pass a federal amendment. One point I'd like to make is that this story will change a little bit when you bring state constitutionalism into the mix. So if you consider the example of direct senatorial elections, it's the elaboration of a system of direct election of United States senators through state constitutional reform that makes the passage of the 17th Amendment feasible. That is to say, it's not really congressional deliberation over the merits or demerits of the federal amendment that brings about the passage of the 17th Amendment. Rather, it's that states have constitutionally and statutorily changed their framework, including through the initiative process for selecting United States senators, such that by the time the process is finished in the late 1910s, 80% of the chamber of the United States Senate relies on direct elections for re-election and ultimately comes to support the amendment that they had long blocked. That is to say, by looking at how reform pressure is vented at the state level, we can better understand how national constitutional change occurs. And my argument, I hope that I've made convincingly here, is that the state constitutional initiative process is a crucial piece in how this phenomenon works. So with that, I look forward to questions and to talking more about initiatives.
Thank you, Robinson. Do people in the room have questions? We can use these microphones to talk to them. Go ahead.
Be good. Thank you both for those presentations. I thought this panel would be a good time to ask this question, and that is, could either of you see a situation in which we would add to the number of states with direct democracy at this point in time? And that is that there's this discussion about the kind of conditions under which direct democracy can have these effects. But it strikes me that we've been rather frozen in time for about 30 years now in terms of the number of states that actually have direct democracy. And the first thought might be, there's no conditions for the legislature to give up its power, and there's very few conventions being called to do that. But we've seen legislatures voluntarily create the initiative process in the past. If we look at how the 24 states with some version of initiative process did so, close to half of them that came about where legislatures created that process. So I guess the question is, could one see a situation in which national groups or state groups could actually be so interested in adding direct democracy to a state that does not have it, that could put such pressure on and we could get a movement on that we could actually see more states adding direct democracy? Or could you not see much of a pathway under which we have any more states join the list of direct democracy states?
Kauser and Bridges are sort of interested in why we see, when the Populist Party is a broad-based national party, only Western and Midwestern states adopt the initiative, or primarily, I should say, the constitutional initiative. And their argument is the conditions for instituting an initiative are that legislators don't trust what future legislators will look like, but they do trust what current voters look like. So they're trying to hand off this constraint power to voters who they think are going to be a safer bet in the long run. So do we have those conditions now? What we see at the state level is polarization. States are polarizing and lockstepping with their national parties. And we also see the electorate doing that. So it's plausible that state legislators would trust their state electorate to embody or to entrench their policy preferences. But because, with the exception of a handful of states, legislative turnover is relatively low, we also don't have the incentive to check future legislators. So I think we have one of the two conditions necessary for it. That's sort of my initial thought based on sort of the account that Kauser and Bridges give on why initiatives are sort of entrenched at the constitutional level. So I'm not sure we have the conditions for it, but that's sort of my initial thought responding to your question, John.
Yeah, it's a great question. I agree with that answer. I think the only thing that I would add is that I think a fair amount depends on the future cohesion or lack thereof within political parties. And if you had, say, one moderate wing that was willing to vote on something with the other party to avoid a more extreme wings, taking over or doing something they didn't want, I think if there was that sort of fracture, you could imagine getting enough legislative buy-in to turn things over to the people. I think that's actually just a variation of what Robinson said of trusting voters more than you potentially trust the next legislature.
Other questions? We've got a little bit of time. Our next panel doesn't start till 9:40, so I can.
I just want to
go ahead.
Just get back to that question again, because I really like it, and it was the main thing I was thinking about as I was listening to you. If someone had told you what American history looks like from, particularly 1820 to 1920, you would have said by 2021, every state will have the initiative, right? I mean, you have this, Miriam, this is all your work about hyper democracy, then eventually distrust of any form of representation, which leads to direct democracy. And so I just want to continue with John's question. I just find it astonishing. Are people suddenly saying representative government's good and that, direct democracy is dangerous, direct democracy is bad? But I find it so surprising that the trend didn't continue and it's really stopped. And it also overlaps. Maybe there's an insight lurking here, but it overlaps with the lack of success of constitutional conventions as a method of change. So that's the other pattern that if you were watching the graph, you would have said, well, yeah, we'll of course always have these conventions. It may be there every 30, 40 years, after the gerrymandering decisions or, whatever it might be, the one person, one vote decisions. But it's just so surprising to me that we've stopped conventions and we've stopped the growth of democracy, and we haven't cut back on direct democracy. It's not like it's going backwards. You could get rid of it and you're not. So I don't know. I find it very interesting. And, what is it that's going on?
Well, hi, Jeff. I think I know that voice, although I can't see you. It would be interesting to done, but which I think, your book maybe invites, which is to compare, each state's avenues for constitutional amendment with some of the other factors we've talked about, because there might be more opportunities that are being used. On the other hand, it might be that some of the same states that have sort of the least felicitous politics for changing the Constitution also have, are the ones where there might be a constitutional pathway, and the ones where the politics might support it, have actually, because not every state is super easy to constitutionally amend. That's not a complete answer. It doesn't explain legislative behavior, but I guess it explains the behavior of people who otherwise would be interested in it, but maybe are not getting it done. But I think it's a question that, ought to be thought about in more detail than at least I have in my work.
Anthony Johnstone, do you want to ask a question?
Yeah, these are such great questions. I hate to narrow things down a little bit, but I had a question both for Miriam and Robinson. Miriam, you talked about the Idaho case, which I've been following too, and will come up in my presentation. What do you think of its I'm trying to understand how you operationalize the democracy principle. So is it a right? You cite rights, you cite Article 1 style guarantees of popular sovereignty, but then does it go to the scope of the right, which I thought was the original point, or does it go to the strength of the state's interest, which is, I think, what happened in Idaho? So puzzling through the question of how the democracy principle clarifies the transformation of the initiative power into some sort of individual or collective right. And then Robinson, my question for you is, what do you think about why not cut out the middleman? I mean, why don't we just see the Article 5 convention calls go all the way, or this intermediate step that some courts have weighed in on whether, this has happened in Montana and other states after Citizens United, whether initiatives can be used to instruct state legislatures to make convention calls?
Hi, Anthony. Thanks for the question. Maybe somewhat unsatisfyingly, I think Jessica's and my claim about the democracy principle is too modest to fully explain most judicial outcomes. In its most modest form, our claim is basically that this is a constitutional principle in state constitutions, like federalism and the separation of power are structural principles of the federal constitution. We could agree that federalism is a principle of the federal constitution, and we could seldom agree on how it should be implemented. So our most modest claim is that you should just think of democracy that way, that it's a structural principle of state constitutions, and how it cashes out in different cases, often folks could disagree about, and that would be fine. That would be the appropriate terrain for contestation. Now, slightly more ambitiously, I think there are cases in which it can be decisive, and maybe the Idaho case was one of them. And the cases in which it can be decisive are, what you might think of as equivalent to the concept of lockups in the political process from the Zakharoff and Pildes article. Times when there's a real breakdown in democracy, and relatedly, when all of our pillars, popular sovereignty, political equality, and majority rule, would point in the same direction, right? So, trying to actually basically eliminate direct democracy from the state constitution by statute, that would seem, unless there's actually some harm being done to political equality, that would seem to offend all of the pillars and would point in the same direction. Other examples in which we think courts essentially have invoked it without naming it include the state courts that have found state constitutional prohibitions against extreme partisan gerrymandering. We think it could also inform cases about certain types of power grabs between the branches. But in a lot of cases, like if you're trying to define the scope of the right of the franchise or something like that, the principle is just going to be one of the things that goes into the judicial analysis and not necessarily spelling out some scope of the right. I think we stop short of saying that.
So on the question of the alternate Article 5 proposal path, Article 5 allows Congress to propose amendments by bicameral 2/3 votes, but 2/3 of the states, 34 states, can call a federal constitutional convention to propose an amendment. And we've actually come close a few times. Direct senatorial elections almost were proposed by Article 5 convention because progressives and populists at the state level wanted to circumvent the Senate. It was actually the prospect of a federal convention being called in the early 20th century that helped the Senate back down. Similarly, in the 60s and 70s, in reaction to the reapportionment decisions, the Reynolds versus Sims, Westbury versus Saunders, and Reynolds versus Sims, Westbury versus Saunders, and I'm blanking on the last one. The states start to propose an Article 5 convention basically to overturn those decisions and to, again, circumvent the federal court. That one comes up just short. What we get then finally is the balanced budget amendment, which comes closest by 1979. You have 30 states filing petitions, which is near to that 34 state threshold. So why don't we actually see this succeeding historically, and where might we sort of be going from here? One is that we see Congress is pretty hostile to being circumvented by Article 5 convention. So Birch Bayh, who was chair of the Senate committee in 1979, he has his staff pretty closely look over these petitions. And in 12 cases for the balanced budget amendments in 1979, he finds that state legislators didn't know, they didn't file the petitions correctly, and that in some cases, they weren't directly calling for states to call an amendment, but rather were calling for Congress through the alternate Article 5 path to propose an amendment. So what you get is state legislators not really sort of thinking too closely, at least in the balanced budget amendment convention case, about the technical aspects of Article 5. And this empowers Birch Bayh to basically throw out some of these petitions. So, you know, if you look at Birch Bayh's records, it's likely the case that we're not actually, or the Senate Judiciary Committee's records, it looks like we actually didn't get that close to a balanced budget amendment convention. So it's, I think, congressional hostility that historically has sort of prevented Congress from actually accepting the petitions in some cases, like the balanced budget amendment, or alternately proposing their own version of an amendment, say in the direct senatorial election case, to prevent a runaway convention. Now, where might that leave us now? What are the prospects for sort of revision from here? I struggle to imagine a constitutional issue that we could get 34 state legislatures to agree on. And that's just because polarization is strong, and the partisan divisions across the state is rough, across the states are roughly even. So on sort of significant constitutional issues, I think that, again, we're sort of stymied by the high Article 5 barriers to amendment proposal. You know, of the amendments, the 33 amendments to actually clear the proposal stage, 27 have passed, but we've had another 12,000 that have never cleared the proposal stage. And so I think Sandy Levinson is basically right to call Article 5 the most significant bars on our constitutional cage, as he roughly put it. So I'd say that supermajority requirements there to proposal are really sort of what's stopping contemporary amendments from making it through the convention process.
All right.
Really quick question.
We better get to the next panel.
Okay, go ahead.
Do you want to tell them what you're thinking as I transition?
Well, Robinson, my question is whether anyone has thought that when the legislatures
Have to ratify, you know, after the Arizona case, would an initiative satisfy that? Does anyone?
Yeah.
You know what I'm saying?
Yeah, the question is, would, if we're asking at the end of the Article 5 process for ratification, would an initiative constitute, would that bind the legislature to ratification?
Well, that, or would it count by itself? That's why the Arizona case is quite interesting. That was the essence of the debate. Is an initiative an act of the legislature? Yeah,
I see what you're saying. Article 5 is sufficiently underspecified that I can't say the text says no. And, you know, in doubt, I would defer to the state legislatures on how they conceive of their ratifying or proposal powers to work. But that's just sort of a top line, sort of very short reading of Article 5 is I think it would be left to the states to conceive of the proposal and ratification process.
Good. Thank you. We're going to get to our next panel.
Well, this panel is looking at a series of the rules of the direct democracy. And my focus today is particularly on the many changes that are made to initiative process rules through constitutional amendments, through legislative statutes, and through initiative measures. There have been a lot of changes made in the last 2 decades in regard to initiative process rules. And really, there's been a surge of interest, even increasing interest in recent years in changing the rules of direct democracy. Just a sample, changes have been made in terms of how you qualify initiatives for the ballot. A lot of attention given to that. How do you get measures, signatures gathered? How do you get them on the ballot? There's been a lot of attention given to a second type of change, that is how voter ratification of direct democracy measures take place, how high or low are the barriers. Third type of changes have been in regard to what subjects can be addressed through initiative measures, how many subjects can be addressed at one time, and whether certain subjects are off limits or within limits. And then fourth, there's been a lot of attention given and some changes made in the rules regarding whether and how legislators can change initiative measures once they've been passed. Can the legislature change them at all? Or are there certain limits on how much so? Now, most of the changes and most of the energy in recent years has been in the direction of limiting accessibility of the initiative process, but not always. There has been some attention also given to energy to increasing accessibility, but the dominant trend has been towards limiting accessibility. I want to focus today on particularly explaining why we've seen this surge of energy in terms of changing initiative process rules. And in doing so, I want to say, let me draw some lessons for scholars and practitioners. Very briefly, let me preview the argument and then let me step back and really kind of set it out in full detail. My main argument is that efforts to change initiative process rules generally emerge in response to disjunctions between the public and elected officials, where groups end up relying on the initiative process on high-profile issues and on a routine basis to bypass the legislature and enact their preferred policies. And in response, the dominant state party that controls the legislature will be led to consider ways of limiting initiative use in the process. Now, one possible avenue, one possible response for the dominant state party could be, let's get rid of the initiative process altogether in this state. There is no indication that the public in any state is willing to take that dramatic step. And so the more viable response is, and where the battle is fought, is not over yes or no to the initiative process, but what should the rules of the game be? And it's important to stress, this is another facet of my argument, and we'll set this out. The party dynamics of initiative process rules changes, they can and have varied over time. That is, at various times in the US history, the initiative process has been chiefly relied on by liberal groups. At other times, it has been chiefly relied on by conservative groups. There are errors when that's taking place. In the 21st century, though, the clear pattern is Democratic officials and liberal groups are on balance more likely to benefit from initiatives, and Republicans and conservative groups more likely to resist them. And this has come about, as I argue, about really you can identify a half dozen issues that have really been at the heart of this disjunction. So that's my argument for today in a nutshell. Let me step back and make good on and set out some details here. Let me start with a framework. What's a framework for if we wanted a general framework or when we would see initiative process rules changes being made? And one way of thinking about this is you've got two dimensions. You've got attitudes towards the initiative process and a theoretical dimension. That is, are you generally in favor of direct representation or are you generally in favor of indirect representation? And here, generally, there's been stability. Liberal groups are more embracing of direct representation, and conservatives dating back to the early 1900s have been more favoring indirect representation. But then there's also a second dimension. That's a theoretical dimension. The second dimension is a more practical political dimension. Which parties and groups are more likely to win or lose through the initiative process in any given time? You got the theory out here, and then you got the political, whether the results come about. Well, here, there's been a lot of variation over time on this dimension, over which groups and parties are going to benefit from the initiative process. And at various times, then direct democracy has benefited liberals, and at times it benefited conservatives. And in this regard, I would argue that groups and officials' attitude toward the initiative process really resembles their attitudes towards other governing institutions and principles. For instance, the Electoral College, the Senate filibuster, judicial review, unilateral presidential action. Added towards these rules and institutions, there is some stability over time, but they're also highly contingent on what results those institutions are producing at any given time. That is, democratic officials are more apt to support the filibuster or more apt to support unilateral presidential power when those institutions are helping to advance democratic policy priorities. And when those institutions cease to be helping advance Democratic Party priorities, groups can shift to downright opposition, just as Republican groups can change over time. So in some ways, the framework I'm suggesting is a general framework of institutional change. You've got a theoretical dimension, do you like the institution? And then there's a practical dimension, who is it helping at any given time? And so focusing on the initiative process, consider the evolution of attitudes on the part of Democratic and Republican officials and conservative and liberal groups towards the initiative process. Let's go back to the origin of the direct democracy in the early 20th century. In the first few decades of the 20th century, the initiative process was in nearly all cases a vehicle for securing progressive policies. It was championed by progressives. It was opposed by conservatives. Just think about the issues that the direct democracy was helping advance at this time. It was helping to secure workers' rights, securing minimum wage, securing maximum hours, securing worker compensation programs. Or it was also helping to secure regulation of businesses, particularly railroads and railroad rates. So that was the case at the early 20th century. It was clear the dimension. We knew who was benefiting from the initiative process. The initiative process between the 1930s and 1950s and 60s kind of receded in importance. It was really big in 1900 to 1920, recedes in importance, picks up again in the 1970s. When the initiative process picks up in use and surges in importance in the 1970s, it's now conservative groups and Republican officials who are the main champions of the initiative process. What's getting passed through the initiative process in the 1970s, 1980s, and 1990s? Well, as we already heard from the previous panel, California's voters' passage of a Proposition 13 tax limitation measure was a model for a number of other tax limitation measures, oftentimes passed through the initiative process and supported by economic conservatives. Social conservatives also turned during this time in the late 20th century. They turned to the initiative process to authorize the death penalty, to limit abortion in some cases, make English the official language in some other cases. And then conservative groups also relied on the initiative process to limit state legislative terms. This led liberal groups and Democratic officials from the 1970s and 1990s, they were the ones expressing concerns about the initiative process during this time. And when you saw people saying, should we expand use of the initiative process? It was conservatives and Republicans that were leading the charge. And folks said, are there reasons to be suspicious about or skeptical about initiatives? It was Democrats and liberal groups in the end of the 1900s. Now we come to the first two decades of the 20th century, and the political dynamics shifted again. It's true, conservative groups will continue to enjoy occasional success in passing tax limitation measures through the initiative process. They'll enjoy occasional success in passing immigrant restriction measures, affirmative action limits. But clearly, liberal groups in the last 2 decades are the biggest beneficiaries of the initiative process, and they're the ones more likely to turn to the process on a regular basis. Why is this the case? One is that of simply 24 states allow the initiative process in a fashion. 16 of those states are heavily controlled by Republicans. It's simply the put that in view of Republicans' current dominance of elected offices in 2/3 of the states with the initiative process, it's not surprising then that liberal groups are more likely at present than conservative groups to see a need for bypassing the initiative, the legislative. That's, as I say, 2/3 of the states with the initiative process. Really, over the last decade, Republicans have controlled the state legislatures. Only 8 of the states that have the initiative process that are really could say Democratic controlled states, at least at the legislature. Now, and so that's the general pattern. That's what I say. That's just the politics of the early 20th century in the states with the initiative process. Now, I don't want to go too strong here. Let me just mention some exceptions. The initiative process in the 21st century is not solely a vehicle for liberal groups to bypass resistant Republican legislators. Sometimes you'll see liberal groups resorting to the initiative process in Democratic-controlled states because they're pushing Democratic legislators even farther than they're willing to go, or they're putting issues on the agenda that are not high on the agenda of Democratic officials. So that's one exception to this dominant trend I'm setting. And you will still see, as I've just indicated, you'll still see conservative groups using the initiative process to bypass Democratic-controlled legislatures in the 8 states that are Democratic-controlled. You'll see occasionally conservatives saying, well, let's pick off an issue or two here that we think we can win with the public. And on still other occasions, the initiative process is, we can take it out of the party dimension. Sometimes it's used on issues that are just not clearly aligned with Democrats or Republicans, lobbying reform or ethics reform in that way. And so that's kind of a break from this pattern. Still, these exceptions haven't been noted. In the current era, the disjunctions between the general public and elected officials in initiative states are most likely to feature liberal groups seeking to use the initiative process to bypass resistant Republican legislators. And I want to argue, and let me turn to the next point of my remarks, it's not just at a general level. You can actually see a half dozen specific issues which have really brought this to the fore. That is, folks groups and legislators don't just kind of wake up in general thinking about the initiative process and let's make rules changes to the initiative process. It's just not top of mind. It has to be certain issues that bring it to their mind. And let me set out a half dozen issues that have been most responsible in the last 2 decades for just focusing attention and leading legislators oftentimes, sometimes other officials say, let's change the rules. Animal welfare is one of these issues. And I would argue that changes in initiative process rules, especially in the early 2000s, have been motivated to a significant and underappreciated degree by the success of animal welfare initiatives. This is one of these issues there where efforts to protect animals, and it can be wildlife, it can be in kind of marine wildlife as well, marine life, that it's oftentimes legislators lag behind the general public in their willingness to support animal protection measures. And so this has led in some cases to direct rules changes. 2 decades ago, Utah changed its initiative process rules. They said, okay, every other initiative needs to get a majority approval by the public, except for wildlife measures. They need 2/3 approval by the public. I mean, it's just a direct reaction to the success of wildlife measures. In other states, it's not in, so in Utah, they just directly target it. We're going to change the rules for animal welfare. In some of the cases, it's more the case that animal welfare measures, along with other measures, are prompting rules changes. Wyoming is one example where they tightened geographic distribution requirements for qualifying measures for the ballot, and concerns about animal welfare measures were one of the factors that was going into place. Minimum wage is another issue. It's really been prompting a number of initiative rules changes. Of the various policies placed on the ballot via the initiative process in the 21st century, none have been more successful with voters than measures to increase the minimum wage. And this is a striking statistic. Voters have approved all 19 minimum wage increase initiatives that have appeared on the ballot since 2000. Maybe sometimes somebody will overshoot and they'll ask for something more than voters are willing to do. That hasn't happened yet in that sense, a pure measure of that kind. So group success in using the initiative process to pass minimum wage measures has played a key role in prompting Republican legislators and business groups to try to push for initiative process rules changes. Now, in some cases, minimum wage increases have played a role alongside other policies in leading to rules changes. In Florida, in 2006, they bumped up from a 50% voter approval rule to a 60% voter approval rule for all amendments, including initiative amendments. One of the things that played a role in this, that was 2 years before they'd had a minimum wage increase pass. There's other measures as well too, but that was one of the measures. In other states, minimum wage initiatives are clearly, you can draw a direct line between minimum wage initiatives and rules changes. Arizona is a leading example here. So in 2016, you had an initiative state, it increased the minimum wage and also required businesses to offer paid sick leave. So they combined minimum wage increase and paid sick leave. A lot of litigation over that. It wasn't successful. The Arizona legislature responded to this by the combination of minimum wage plus else by putting on the ballot next year a measure that would introduce a single subject rule for initiatives in Arizona. Arizona has a single subject rule for legislation, which actually featured very prominently in a budget bill just in the last week in that sense. But they do not have one, the court said, for initiatives. It's that minimum wage passage that prompts them to say, hey, maybe we need a single subject rule for initiatives in Arizona. Marijuana legalization is another issue that's prompted initiative rules changes. I said that minimum wage measures have been more successful than any other, and that's true. But if you asked one group that's been more benefited from initiative process in the last quarter century, it would be marijuana legalization supporters in that way. And this is a case that just state legislatures, their support has lagged behind the public for various reasons on marijuana legalization. And so some of the resulting, so you've seen a lot of marijuana legalization, medical and recreational, pass through the initiative process. So this has led to a lot of push for rules changes. Let me say, some of the resulting energy for rules changes has come from supporters of marijuana legalization in that way. And here the idea is that sometimes folks have gotten marijuana legalization initiatives passed, but the resistant legislators come back and say, nice try, let's kind of change your work, or let's only go halfway towards what you wanted, or let's actually not implement what you wanted. And so here the energy has come from legalization supporters who said, we need to change initiative rules to better protect ballot measures once they pass and prevent state legislative interference in that way. This was the origin 2 decades ago of Arizona's very strong Voter Protection Act, which it makes it very difficult for the legislature to alter an initiative once it's passed. How did Arizona get that 2 decades ago? Precisely because marijuana legalization supporters were upset that the legislature had tweaked an existing medical marijuana measure. In other states, opponents of marijuana legalization have been the one leading efforts to change initiative process rules. And here the leading example is Ohio in the mid-2010s, where marijuana legalization supporters put an initiative on the ballot. And as a competing measure, opponents placed on the ballot measure an anti-monopoly amendment. They say you can't use the initiative process or make it more difficult to create monopolies. It turns out that the marijuana legalization measure would have, in some sense, given monopolies of some kind to folks in kind of marijuana dispensaries. That anti-monopoly subject matter limitation measure on initiative measures passed. And that's the origin of how Ohio changed its rules in that regard in response to this nascent marijuana measure. Medicaid expansion is another issue that's recently prompted initiative rules changes. Really, the initiative process has been used for the last 2 decades in a number of cases for committing state governments to spend more money on certain programs. Sometimes they'll provide accompanying tax revenue for that. Sometimes they won't. And so this, in a general sense of increasing spending programs, has been a prompting for initiative rules changes. But the real specific genesis for these efforts in the last 5 years has been initiatives for Medicaid expansion. Basically, Medicaid expansion efforts stalled in state legislatures about 2015. The energy, for the most part, there's been some legislative measures since then, but for the most part, the energy supporters of Medicaid expansion turned to the initiative process. 6 measures between 2017 and 2020 were put on the ballot, expand Medicaid. All 6 were approved in that way. And these Medicaid expansion initiatives have in turn prompted responses from legislators. We already heard in our previous panel, Idaho legislators responded to passage of a 2018 Medicaid expansion initiative by enacting a number of statutory initiatives to the state's initiative process rules. Those have in turn been reviewed by courts and invalidated. Meanwhile, the South Dakota legislature is currently taking a step toward changing initiative process rules this very year and putting a measure on the ballot next year that's designed to thwart an anticipated Medicaid expansion measure. And they would change the rules in such a way that would really make it difficult for this Medicaid expansion measure to pass. Let me just give 2 other issues just kind of briefly. One is election-related policies have also played a role. The idea here is that folks use the initiative process to adopt independent redistricting commissions or to make other changes in voting rules. And legislators, again, in this case, mostly Republican legislators, have pushed back against that. So when Michigan voters passed in 2018 a pair of elections-related initiative amendments, including an independent redistricting commission, that played a key role in leading legislators to make several changes within the next month that erected additional barriers to using the initiative process. Most of those were, in fact, struck down by Michigan courts. And then South Dakota voters' approval in 2016 of a wide-ranging campaign finance initiative prompted state legislators to push a number of measures to limit future initiatives. And one thing that came out of that was that's how South Dakota got its current single subject rule, was in response to this wide-ranging campaign finance and ethics reform measure. And I said, okay, let's get a single subject rule for the future. And then the final issue I mentioned, this has particular Nebraska implications, so I'll close with this one on the issues part of my talk. Groups supporting gambling have resorted to the initiative process in a wide range of cases to expand gambling operations. And this is the origin of Nebraska's current constitutional provision insulating, to some degree at least, voter-approved initiatives from legislative interference. Back in 2004, you had gambling groups trying to place on the Nebraska ballot a package of gambling-related initiatives, but they were concerned that the legislature might interfere with them if they did pass. So they also placed on the ballot a measure, that initiative, remember, requiring a supermajority legislative vote to change policies enacted by the initiatives. That passed. And so that's the origin of the tough provision that Nebraska has in its current provision, in its current constitution for protecting, to some degree, initiative statutes from legislative interference, came about as a result of gambling groups. So let me just take a few minutes. So this is what I said, this is driving the process. I've got an overall framework for explaining the changes, but then you've got specific issues that are kind of activating the energy in that way. I alluded to the very beginning of my talk for specific types of changes. And let me just kind of say a little bit more about, so what, if these are the driving forces for change in initiative process rules, so what specific changes have come about? Well, as I said, one set of rules changes is focused on regulating the signature gathering process. For instance, legislators have been particularly active in regulating the persons who gather signatures, requiring you to wear a badge if you're kind of gathering signatures, require you to register with state officials, preventing them from being paid by the signature, placing restrictions on who's allowed to serve as a signature collector. Other rules in this kind of general kind of set of signature gathering process rules changes, they focused on adding or strengthening geographic distribution requirements. That's been a real key bit of energy. They say, oh, okay, so we've got to get 8% in the state of a whole. Oh, but you have to get 8% of those in half of the state's legislative districts. Or, as we heard in Idaho, or in all of the state's legislative districts. So you can really tighten up the rules depending on whether you require certain geographic distribution. And then changes have also targeted, interesting enough, might not be top of mind, the deadline for when you have to submit the collected signatures. The earlier you set that deadline before the election, the tougher that you make it for groups to be able to meet that deadline. So a second set of changes, that first set of changes is how you kind of make it tougher or easier to get these measures on the ballot. Second set of rules changes have focused on the voter approval part of the story. And here there's been several key efforts. Should it be just a majority approval? Or should it be, as Florida said in 2006, 60% approval? Or as Colorado said a half decade ago, should it be a 55% approval rate in that way? So you've got a lot of energy there to increasing supermajority voter ratification rules are definitely on the table in some of these states. The third type of the four changes that I've mentioned is these are addressing the subject matter of what you can take up in two separate ways. One is, I've already mentioned, sometimes states say, well, let's just designate certain subjects off limits for initiative measures, or let's set more rigorous requirements if you're dealing with these subjects. This would be the deal with the wildlife measures in Utah. Okay, let's set those up for special treatment, wildlife measures. But then the other, and this is very much obviously for the origin of this whole conference, the other approach has been to deal with single subject rules. I've already mentioned that South Dakota and Idaho have rather recently imposed single subject rules. They didn't have them before, but half the states have the single subject rules for initiatives, some don't. That number is increasing. And as I say, Arizona voters next year will consider whether to add to that list as well, whether to make Arizona a single subject rule state for initiatives. And then the fourth set of rules changes, the fourth and final set I'll talk about, has focused on the rules regarding legislative modification of policies enacted via initiative statutes. Right now, half of the states that allow for initiative statutes, they restrict in some fashion the legislature's ability to alter or reverse policies enacted through the initiative. And there's various ways that it can be done. Some states say there's a time limit. The legislature can't do anything within a few years of it's passed, or the legislature can only do things with a 2/3 or 3/4 majority, or some legislature can't touch it really at all in that sense. Most of the energy for changing these legislative alteration rules in recent years, as I say, has come from supporters of the initiative process. They've been trying to add to the number of states with voter protection measures. And as I say, we've seen a few states doing that. At other times, though, rules changes have been championed by officials who oppose recent initiative measures, and they want to reduce the level of protection they enjoy. Let me just flag an issue here. Arizona legislatures this year placed on next year's ballot an amendment that would tweak that state's existing Voter Protection Act by making it easier for legislators to change initiatives once they're passed. So you can see this is going in different directions. Some folks are saying, yeah, let's protect the voter measures. Other legislators saying, I don't know if they need that much protection. Maybe there's some flexibility here. Let me conclude with a lesson to be drawn from this subject. I wanted to make the point that there's a lot of energy being dedicated toward changing initiative process rules. I wanted to make the case that I try to explain where that energy is coming from, both in a general framework and very specific framework for the 21st century. But I suppose, let me step back even broader. My overriding purpose today is actually to try to direct legal scholars' attention away from a primary focus on judicial interpretation of initiative process rules, and to focus as much as anything on the fact that these rules can be changed themselves by constitutional amendments, by legislative statute, and by initiative procedures. So it's understandable that at a legal focused conference, we'd initially focus on, so what have the judges done in interpreting these rules? How could we persuade them to adopt a different interpretation? But what I've been trying to kind of focus on today is that those rules themselves can be changed without judicial interpretation. And this has implications. I'll close with this. This has particular implications for Nebraska right now. Clearly, the origin of this conference is during the last decade, the Secretary of State of Nebraska and State Supreme Court have had multiple opportunities to interpret the state constitution's single subject requirement. And they've interpreted that rule in ways that have occasionally led to removal of high-profile ballot measures. As we know, just last year, a medical marijuana legalization initiative was removed for violating the single subject rule. My point today is, if one's dissatisfied with that, one could try to persuade the court, I think you've gotten it wrong. I think the dissent had the better of the argument. I think this is how we ought to interpret the single subject rule going forward. But that's not the only game in town. You could also change the wording of the single subject requirement to accomplish the goals that you want. And earlier this year, there was some discussion. I don't know how it went very far, but there was at least a constitutional amendment was proposed in the Nebraska legislature that would change the wording of the single subject rule. The current wording says initiative measures shall contain only one subject. A proposed rewrite of that reads as follows. Initiative measures shall contain only one general subject, which may include provisions that have a connection to the general subject of the measure. And so I'll close with that. There's a lot of energy going around with changing initiative rules themselves. It shows that those rules themselves are within our power to change. One option, if we're dissatisfied with how those rules are currently working, is to persuade judges to change their interpretation. The other option is change the rules themselves. So thank you very much.
Thank you for the opportunity to participate in this program, and especially for the opportunity to do so remotely. I'm sorry I couldn't be there, and it sounds like it's a great group that you've got both in person and virtually. My topic is, and I'm picking up exactly where John left off, on single subject rules. I should caution that the paper that I wrote and what I'm going to be working from was actually about the application of single subject rules to legislation, not to direct democracy, not to voter initiatives. And we'll talk a little bit about that, but then I am going to try and adapt it, extrapolate to the implications of single subject rules for voter initiatives, and then actually talk about the two Nebraska cases that John alluded to that I guess have triggered this conference, which I think rather nicely illustrate the inherent indeterminacy and the inherent difficulty of the single subject rule. So what are single subject rules? Single subject rules are provisions widespread in state constitutions. And again, thinking this is a conference on state constitutional law more broadly, as well as direct democracy in particular. Unlike the federal constitution, which says very little about how Congress operates, most state constitutions have detailed provisions regulating how their legislatures operate. They have special act bans. They have many states prohibit the introduction of substantive legislation and appropriations measures. There are aging requirements. A bill must sit on the legislator's desk for 3 days, say, before the legislature can vote on it. There are requirements that every bill have a title that clearly identifies its contents. And most commonly, there are requirements that no law contain more than a single subject. 43 states have some kind of single subject requirement. The idea really dates back, well, there are traces of it in Roman law and in English law, but it really caught fire in the US in the early 19th century. The post-revolutionary and early 19th century state legislatures could be quite wild and did a lot of very dramatic things. There was a real surge in democracy at that time as the suffrage expanded and as new groups began to enter legislatures, as legislatures ceased to be the preserve of kind of local elites as they had been before the revolution. And the legislature's doing a lot of wild things, including racking up a lot of debt and changing a lot of laws. And there was a reaction. And beginning in after the War of 1812, you begin to see the first stirrings of the idea that there should be some limits on how legislatures behave. And by after the Panic of 1837, you saw that and much more widespread as many states basically got themselves into serious fiscal difficulties. And starting with New Jersey in 1843, which there had been some earlier measures that limited certain kinds of bills to a single subject. New Jersey in 1843 amended its constitution to require that every law have a single subject. And every state that entered the union thereafter, as well as many of the states that entered before, adopted some kind of single subject requirements. And I think right now it's 43 states have them. The goals of single subject rules can be enumerated. They promote deliberation. If a bill is focused on a particular subject, it's easier for legislators to know what they're talking about, to deliberate, to make a judgment as to what they want, maybe to see changes. It promotes public transparency. It's easier for the public, including interest groups that might be affected, or consumers, or others who might be affected by a bill, to understand what's in it. If the bill is limited to a single subject, it promotes accountability. Once the bill has passed and become a law, it's easier to hold legislators accountable if we know what they were working on. And if the bill has a single topic. When bills have multiple topics, the legislator can say, I voted for it because I liked A, B, and C, and I didn't care for D. Don't blame me for D. And relating to that is some notion of non-coercion of the legislators being forced to support that D, even though they don't really like it, in order to get A, B, and C, which they think is good for their constituents, good for the public. And some have even pointed to the single subject rule as a way of protecting the governor's veto. Some states have the item veto, many do not. Governor, like the president, has to accept a bill as it comes along. And so it seems as though and so again, it also protects the governor's interests. These are the principles behind single subject rules. One also, I've sometimes seen some people argue for them more in terms of the consequences. There's a concern that if you don't have single subject, if you have omnibus legislation, it gets easier to tack on things. So-called Christmas tree bills. And many people have argued that the growth of government, the increase in spending at the national level is a consequence of the lack of any kind of single subject requirement in Congress. You get omnibus measures, you get huge bills like the Affordable Care Act, or the infrastructure bill that just passed, or the pending Build Back Better legislation, which have hundreds of pages, thousands of pages, many items. And people see in the lack of single subject as a limitation, a reason for the growth of government. All this is very nice. In principle, there are lots of good principled arguments behind the single subject requirement. But, and really this is the focus of my paper, courts have had a hard time, a really hard time, defining subject. A subject can be as broad as law, or the criminal code, or torts, or transportation, or as narrow as the renaming of a specific bridge, or anywhere in between. There is simply no clear and accepted definition of subject either across states or within states. In fact, you just see inconsistency everywhere. Every law can ultimately be broken down into something smaller. All laws are composed of multiple, virtually all laws are composed of multiple parts. And indeed, the courts basically recognize this. The courts very quickly move on from talking about single subject to recognizing that many bills have more than one, I'll call it a topic in it, more than one theme or strand or provision. And the question is, how do these relate to each other? How do they, to use a term that many of the courts have used, and we also see in Congress sometimes, are the different elements of a bill germane to each other? And the language that I've seen in cases includes rationally related. Are the different parts rationally related? Is there a unifying principle? Is there a natural and logical connection? Is there a common purpose or relationship between the topics? Do they have a nexus to a common purpose? Do they fairly relate to the same subject? Do they relate directly or indirectly to the same subject? Is there a common thread or filament? I like that one. That's from Minnesota. And the language that the Nebraska court has been using, is there a natural and necessary connection among them? I'm not sure that any of these things give us any more clarity than the word subject itself. And as you watch courts apply these across the board, I think I've read over 100 cases, it's hard to see any consistency in how courts do it. I think the subject, the concept of the subject simply remains impossible to nail to the wall. As a result of that, I think many courts then have, including the Nebraska court in the cases, which is illustrated in the cases that I guess gave rise to this conference, sort of shift from trying to come up with a kind of an epistemological approach, what's a subject, to maybe a more normative or purposive approach, trying to figure out what is the single subject rule trying to prevent. And many of them have focused on this concept of log rolling. Indeed, log rolling looms large in the Nebraska cases, in both majorities and the dissents, and maybe telling us that maybe log rolling doesn't help all that much. What is a log roll? The concept of log rolling, and I should say that the term log rolling is always used pejoratively. And to call something a log roll is to criticize it. No one has ever used, at least not in the courts, has ever used log roll in a positive way. The idea is that there may be two proposals out there, A and B. Neither one has majority support. Let's say each one is supported by 1/3 of the legislature. But if you attach the two together, you get 2/3 of the legislature and it'll pass. So the concept of a log roll is you take two different items unconnected to each other, neither of which could pass on its own, but if you join them together, both will pass. And that's the idea behind a log roll. Some critics or some scholars of the single subject rule have also added the concept of the rider. This is particularly the work of Michael Gilbert at Virginia, which is to say that there might be a bill that does have a majority, which is very likely to pass. Maybe it's must-pass legislation. Maybe it's an appropriations bill. Maybe it's something popular. And somebody in the legislature, the speaker, the majority leader, the chair of a powerful committee, is able to sneak into it something which could not pass on its own, but if it's attached to a likely to pass bill, can ride along. And that's a rider. And again, the idea is that by attaching something that wouldn't be there otherwise, you're enabling something to pass that wouldn't have passed before. So log rolling is almost always used pejoratively, as the Nebraska courts do. The problem with there are two problems with dealing with log rolling. One is conceptual, which is log rolling is actually another word for compromise or deal making. And as we have talked about in the modern Congress, given it, or many legislatures, the degree of polarization has actually made it very difficult for legislators to reach support across the party aisle and make deals. We often see gridlock or the inability to get things done. People praise the concept of compromise or deal making as a way of getting things done. Well, that's just another term for log rolling. If we think of the infrastructure bill that just passed, that was an agglomeration of hundreds, maybe thousands of items that together were necessary in order for that bill to get through. It's not clear why that's a bad thing, as to if in order to build a constituency that gets something important done, what's wrong with that is the question. Log rolling presumes that it's wrong, but if you call it compromise or deal making, we think of it as a good thing. Moreover, even conceptually, it's not quite clear why log rolling is so bad. The assumption is that if only 1/3 of the legislature supports it, the other 2/3 are opposed to it with equal intensity as the 1/3 that supports it. That's often not the case. You may often have a legislative minority that feels strongly that something ought to pass, and the majority is kind of indifferent or maybe weakly opposed. but more indifferent than actually opposed. They just don't care enough and they wouldn't bother to support it. But if you can take two minorities, each of which strongly support something, neither of which is big enough, and you come together, and the group that supports A is indifferent to B, and the group that supports B is indifferent or very slightly opposed to A. Basically, on balance, if you get 2/3 support for something, it's still likely to reflect overall support within the legislature, that the opposition has been weak and the intensity of support has been strong. So it's actually something that's probably quite popular within the legislature overall and might have broad public support too. So, so log rolling conceptually, it's hard to figure out why it's necessarily a bad thing. And then in particular, of course, it's hard to tell because it just restates the single subject rule problem. Something is a log roll if you've got two unrelated topics, neither of which could pass on its own. But what if the two are related? What if the two are part of the same subsets of the same broader issue? Is that a log roll, or is that just a broader definition of what's the issue? So that's, I think, the basic conceptual problem. And one of the reasons why the single subject rule, even when turned into an anti-log rolling rule, has proved so elusive. It's proved so difficult to come up with a consistent and predictable application across states or within states. Well, I've been talking about legislatures until now, but this conference is about direct democracy. So what about the single subject rule in direct democracy? My understanding is that something like 18 of the 24 states that provide for voter-initiated legislation also have a single subject rule for those voter measures. There are some arguments that would urge courts to be more aggressive in enforcing the single subject rule against initiatives than against regular legislation, legislative legislation, I'll call it. And there are some arguments that would call for courts to be less aggressive in enforcing the single subject rule against voter-initiated legislation as compared to legislature legislation. The reason for more enforcement would be that, for me, the best case against the single subject rule, or the best case, I should say, for deferential application by the courts, is the respect for legislative compromise. But there is no legislative compromise for a voter-initiated measure. Voter-initiated measures don't come out of the wheeling and dealing of multiple legislators and multiple interest groups within the legislative forum. They come out off the pen, or I guess the computer, of a proponent. The proponent might be a coalition. The proponent might be an association of groups, or it might be an individual or a single interest group. And there's no opportunity once the initiative has been certified and going on the ballot for further compromise. There's no opportunity for further deliberation. There's no opportunity to get the drafters to revise it once it's on the ballot. So there's less of a need to defer to legislative compromise. So you might think that courts ought to be tougher. Secondarily, it may be the argument that the measure be clear and understandable and internally consistent might be stronger for legislative initiative than for voter initiative than for legislative measures, because legislators are professionals, or at least they have professional staffs that will help them understand what's in a bill. There'll be committee reports in some places. There'll be internal mechanisms that help educate legislators as to what's in their bills, so that even if it's a complex multi-part bill, they can have a good sense what's there. Voters are not professional lawmakers. Voters are being called upon to take one day, a couple of hours out of their lives, at most maybe a couple of minutes, to read the bill, to think about it, to maybe look at some of the literature or listen to some of the ads, and come out on it and make a decision. So there's a stronger argument that a voter initiative should be clearer and understandable and internally consistent than there would be for legislative legislation. So both of these arguments, the fact that there's no opportunity to modify once the measure is on the ballot, and the fact that voters are amateur legislators, suggests that courts might want to take a more aggressive role in enforcing the single subject rule in direct democracy. But there are also counter arguments. For one, there's one of the strong justifications for the single subject rule for legislators is so that the voters can hold their legislators accountable. If a bill has many parts, some of which are popular and some of which are not, it may be harder to hold the legislator accountable for the thing that the voter doesn't like if that was tied up with something that the voter did like. That's holding representatives accountable which I think is one of the arguments for the single subject rule for legislation, is obviously irrelevant. For voter initiatives, the voters are the legislators. There isn't that the voters can't hold themselves accountable. They know what they're doing if they have an opportunity to read the bill. So the accountability of representatives, I think, drops off the table and might be an argument for a more deferential judicial approach. The other is, I would argue, is that there may be less need to worry about surprise riders. The concern about riders is one of the strongest arguments against for enforcement of the single subject rule for legislatures. The classic rider is something that's popped in at the last minute, maybe in a conference committee, or maybe by the majority leader or the speaker or the chair of a powerful committee as the bill is sailing along, and it gets buried in the small print, and or members of the rank and file in the party have to go along. And many legislatures have short deadlines. Many of them have 60 or 90-day limits, and a lot of things happen rapidly at the end that make it difficult for legislators to process everything. There's less need to worry about surprise, unfair surprise for voter initiatives, because the voter initiative is qualified and placed on the ballot typically about 2 months before the election. So for 2 months, voters and especially interest groups and the media, proponents and especially opponents, have time to check into what's in the bill, and to publicize anything they think might be a negative. So I think that the dangers of unfair surprise, which are very high when a legislature may be meeting only 60 or 90 days every 2 years, or even for a longer session, but they're rushing to get done through adjournment, it's less likely to be a problem for voters, given the fact that the measure is sitting out there in public for 2 full months typically. And finally, voters, unlike legislators, are less likely to be subject to party and leadership pressure to go along, to accept something that they don't like that's been tucked into a bill that the party overall supports. Voters are not under any party or leadership pressure. They're voting, nothing that they're doing turns on it. Whether or not they're going to get a committee assignment or whether or not they're going to get a larger donation from a campaign committee is irrelevant. And of course, they're voting in secret. So I think all those are arguments for less aggressive judicial enforcement. But candidly, whether you take more aggressive or less aggressive, the ultimate problem is still the indeterminacy of the subject. And I don't think that's going to be a problem, whether it's legislative or judicial. Maybe I'll say just a couple of minutes about the 2 Nebraska cases that triggered this, the ones dealing with gambling and racetracks. Because I think the gambling one in particular, but even the gambling one and medical marijuana one, even medical marijuana one, actually display a lot of confusion about the concept of log rolling. So in the gambling one, and also I think the action of the Secretary of State for the gambling 3 measures in saying that you would have to disapprove all 3 because they're internally related, struck me as actually taking the single subject rule and turning it on its head. Nothing could be more pro single subject rule than splitting up a measure into some of its component parts. And to say that it was antithetical to the single subject rule to have the gambling measure proceed in 3 parts strikes me as literally bizarre and truly 180 degrees wrong. As for turning to the measures themselves, in particular, the constitutional measure, which I think is the one that drew a particular dissent, the dissent in that case relied heavily on the idea that legalizing gambling and legalizing it at racetracks are 2 separate things, and therefore they were being log rolled. Or also either that or was legalizing gambling and legalizing it through certain people who are certain kinds of providers of gambling services. I wasn't quite clear as to what they thought the 2 different parts were. That strikes me as a misuse of the log roll concept. To log roll is to say that in order to get A, you need to have B. 2 different things, whether it's road A and road B in a roads project, or even road A and port project B in a broader infrastructure bill. But in the gambling case, it was not A and B weren't different, which is A is to say gambling and B is to say racetracks. But it's more like more or less of the same thing of A. It's more like saying, we're going to appropriate $50 million for road projects. Well, that's 2 things, road projects and $50 million. And to say that, gee, it's coercing voters because some voters would rather have $100 million and they're stuck with 50. Or some voters would rather have 25 million to say it's stuck with 50. In the gambling one, at least, the 2 different elements which the dissenters, and it was a significant fraction of the court, thought were log rolled, were actually more or less of the same subject. And if you begin to think that more or less of the same subject is a log roll, then virtually everything is a log roll. Similarly, I would say that maybe it's a closer case, but the medical marijuana one struck me as very similar, with the majority saying that it was log rolling two different things, which was to legalize possession and use, and legalizing production for sale to those who could possess and use. The court treating that as two unrelated topics. Again, I think there's a very good argument that they're two more or less of the same thing. Moreover, it seems unlikely in that case that there'd be a lot of coercion. It seems unlikely that, very unlikely that the people who are inclined to support legalization of production for sale would be opposed to legalization for possession and use. Maybe slightly more likely that the supporters of legalization for possession and use might not support production, but clearly some voters could support both. So it struck me as, although in both cases, opponents were using the concept of log roll, it strikes me as really a misuse of log roll. These might have been different elements of it, might have been different things, but it seems unlikely that they were commanding different groups supporting them. But as I think maybe more important than whether or not these cases are right or wrong, is to show just how open these cases, how open single subject rule is to particular judicial preferences, and how unpredictable it can be what courts are doing. That the single subject rule provides an opportunity for courts to act on their underlying subject matter preferences with respect to the issue, even if they don't think that they're doing that. I mean, I don't mean to suggest that that's what was going on here in either one of these things intentionally, but given the extreme indeterminacy and malleability of subject, it would not be surprising if motivating judges was some underlying views about the nature of the proposal itself. So maybe one final thought is, how do you enforce a single subject rule? One reason you might argue, this gets back to the legislatures versus voter initiative, and I'm going to finish with this. One argument for enforcing it, for having courts enforce against legislatures, is that it seems unlikely legislatures will ever enforce it on themselves. Indeed, the whole reason was to constrain legislatures and to say that compromise and deal making may be a good thing, but it may go too far in terms of coercing legislators, in terms of hiding the ball, in terms of legislative leaders being able to manipulate and coerce their members. So maybe we can see it as an outer bound. Because there's no one who's going to enforce it on the legislatures unless it's the courts. Even the governor can't do it in a state that doesn't have an item veto. Who can enforce the single subject rule if it's for voter initiative? Well, one argument is that the voters can enforce it. I haven't looked at this lately, but my understanding is that if one looks at voter initiatives in gross across the board over many years, voters tend to vote no on a lot of things. Many voters are small c conservative. And if they don't understand something, or they're not sure what something is going to do, they're likely to vote no. I mean, we just saw this in New York, where 3 of the 5 ballot initiatives were turned down by relatively substantial margins, even in the absence of even though at least 2 of them, the proponents thought were very non-controversial. It turns out they were wrong. And one of the ways in which opposition to an initiative can be made is simply to say, to point out the things in it that some voters might find unattractive. The more that there is in an initiative, the more likely that opponents will be able to find some things in it that opponents are going to find unattractive. So maybe there's some outer bound role for the courts in enforcing the single subject rule. But you could argue that in addition to the courts, one important entity for enforcing the single subject rule is the voters. And because the appearance of multiple provisions provides an opportunity for opponents of the measure to focus on things that the voters might find unattractive. Thank you very much. I am done.
Thank you, Richard and John. This is super fun for me to have everybody coming to sort of my home turf. I teach here at the College of Law and talking about a topic that I really care about and I spend a lot of time talking about, and so it's really fun for me. It's always very exciting to be sort of the junior member on one of these panels because of being with such distinguished scholars like John and Richard. But then I'm always disappointed that although I'm the youngest and most junior member, I'm also the member with the least amount of hair on these panels. And so I feel like I can't even catch a break as far as that is concerned. Our panel is curated to some extent to move from the super general down to something that's more specific. And so I'm going to talk about a very specific issue, and I want to talk about the intersection of the single subject rule, state constitutional amendment processes, especially the initiative, and then a current sort of phenomenon that relates to some institutional factors as well as hyperpartisanship. And I'm going to make the point that the intersection of those three things is actually causing the single subject rule to be applied in ways that is completely inverting what should be its fundamental purpose. And that we're in sort of a unique period where the single subject rule, I think, is being distorted in some fundamental and dangerous ways. So now before I kind of lay out my argument in that regard, I just want to quickly provide some context, which we're now sort of should vaguely be familiar with. There's roughly 18 states, depending on how the Mississippi Supreme Court is feeling from day to day, that have in their constitutions a process whereby citizens can amend their constitutions through the initiative process. And within those states, the initiative, the constitutional initiative, is a pretty significant force in constitutional politics. And measuring this, you could probably look at it from a few different ways, but if you just look at money, for example, that's expended or contributed to statewide ballot campaigns, in 2020, there was over $1.24 billion contributed to these campaigns. So there's significant energy and there's significant sort of interest that's being poured into these campaigns. Another way to look at the significance of this might just be to track the topics, right? What's on these things? Is it stuff that we really don't care about, or is it capturing stuff that we care about? And in fact, if you were to sort of create a roster of these topics, as John sort of did for us a second ago, it sort of looks like the list of things that we as Americans care the most about right here and now, right? So you've got Medicaid expansion under the Affordable Care Act, you've got the marijuana legalization issues that are going on, you have marriage equality right at the sort of turn of our century, you've got voting rights, and a variety of different issues related to voting rights, and then sort of most recently, we have a whole new set of issues relating and percolating up through the initiative related to reproductive rights, and that's actually been a long-standing sort of trend. These issues just sort of reinforce the fact that the constitutional initiative is a significant force and factor in constitutional politics, especially in these initiative states. Again, as John just sort of described to us, what this means is that the stakes for regulating it are pretty high, right? It matters how it's regulated, and there's a lot of interest in maybe getting strategic advantages in affecting the regulation of the initiative. And so the states have done a variety of different things, right? One of the most common, though, as we know, is the single subject rule, right? It is an attempt to regulate the initiative in a way that hopefully makes the initiative better. And the single subject rule, again, the count on here is a little bit outdated because of the Arizona case, but the single subject rule is relatively common amongst these initiative states. And the provisions that sort of lay down the single subject rule across the states, as Richard was explaining, they're super vague, right? They tend to be incredibly general and not contain a lot of content themselves. This is the Oregon provision, and here's the Nebraska provision. And you can see sort of, the room for interpretation that Richard was illustrating is very obvious just from the text of these provisions. There's an incredible amount of space for interpretation. Now, the purposes of these rules seem quite laudable, right? Like these rules, hopefully, even in the initiative context, could help improve voter choice by making the decision clearer and focusing on one thing. And as a result, voter preferences, when they're registered for an initiative, we could feel that the legitimacy of those preferences is really strong because it's been focused in on one particular issue. And this is one way that the single subject rule could work well in the initiative context. It also relatedly could help deal with problems of log rolling, which could undermine perhaps the legitimacy of voter preferences as registered on a particular ballot question. And so in concept, this sounds like it could be a good thing. But as Richard already explained to us, it hasn't necessarily played out that way in judicial application. Because of the vagueness in these provisions, the courts have kind of been all over the place on what to do with this. And there's been some really compelling political science research into judicial decision-making in this context. And one of the things that correlates the most often is the judge's ideological sort of sympathy for the underlying merit of, or the underlying issue in the ballot measure, right? And that seems to correlate time and time again, which just reinforces this notion that the rule is so vague that judges are left, whether consciously or subconsciously, to fall back on their underlying feelings about the merit of the measure itself. So all of this, to me, makes a lot of sense. It presents pros and cons for the initiative and the single subject rule in the initiative context. But I want to try and add what I think is an even deeper problem with it. And I think what is happening in today's day and age is the single subject rule is being invoked in many cases as a weapon on behalf of recalcitrant governors and state legislatures to fend off attacks or realignment by consolidated statewide popular majorities on a particular discrete policy issue. And so I'm going to try to kind of get you there and walk you through some of the conditions that I think that are in place that are making that happen. And I'm going to make 3 points in this regard. So the first is that I think we need to be very careful in theoretically refocusing the single subject rule. In the cases, the single subject rule, as I read them, tends to get sort of elevated as a good in and of itself. It gets detached from the initiative in many key ways. So my first point is just that we need to reattach the single subject rule as a rule that is intended to enhance, complement, and be part of the initiative as a whole. That point is important in order to sort of enrich our discussion of how the single subject rule should be applied. The next point that I want to make is that in our current sort of moment, there are some very real incentives flowing from partisanship as well as flowing from structures of state government that often result in true misalignment between outputs from state government, from governors and legislatures, and popular statewide majorities. And we see this happening on a variety of different issues, but there is often this misalignment. In initiative states, that alignment will often be corrected, or misalignment will be corrected through the initiative, right? So citizens get together, interest groups get together, they take advantage of the opportunity of the initiative, and they change the policy output from state government to better align with their preferences. And this seems like a wonderful victory for the initiative. We're happy that we have the initiative when this happens. What's going on, though, is that the state government officials and legislatures, they have developed a really sophisticated playbook for how to undermine, evade, and get around these initiatives. And so as they make these moves, and initiative actors and interest groups and citizens watch all of this happening, the initiatives themselves, and this is sort of my third point, the initiatives themselves get crafted to address the countermeasures. And so now you have initiatives that have embedded within them counters to the countermeasures. All of this is fine and well. It can result in some really effective initiatives, but the problem is that it runs the initiatives headlong into the single subject rule. Because as the initiatives are being forced to expand in order to truly effectuate the realignment between state popular majorities and state government, in order to do that effectively, they're broadening in their scope, they're broadening in their detail, and it's essentially teeing them up for an easy challenge under the single subject rule. And this is how, in many respects, the single subject rule is being inverted, and it's being flipped around to protect recalcitrant government rather than to enhance the quality of the initiative. So I'm going to develop each of those in turn, and then I'm going to offer some very preliminary thoughts on what this might mean for doctrine and how we should actually approach the single subject rule going forward, and if it could, I think, provide a little bit more clarity. So let me just first sort of theorize the single subject rule to a bit. And this is a very, very sort of general portrayal, but I think it's one that is important because it's been kind of lost in the cases. So the single subject rule as applied to the initiative is somewhat interesting because in the history of its adoption, it gets kind of swallowed into the initiative early on without a whole lot of critical thought, especially in the convention debates where it's first kind of transferred over from the legislative context into the initiative context. there are sort of many conventions where it's not discussed in much detail at all, and it just kind of gets adopted. And so the history in many states is kind of unclear as to why it made or was pulled from the legislative context, as Richard was talking about, into the initiative context. There are exceptions. So California has this really elaborate history where they had these sort of crazy ham and eggs initiatives, as they were called. They were basically just massive omnibus initiatives, and their single subject rule was in direct response to those. But in a lot of states, if you were to even ask the people who were involved in these conventions why it was pulled into the initiative, I don't know that they would have had a great answer based on what's in the convention debates, at least. What that means is that the rationales and the application of the doctrine has been largely supplied by courts in judicial opinions, drawing upon sort of these understandings from the legislative context. And what that means is, I think, that the basic logic courts have applied to the theory of the single subject rule is that when we have the merging or the bundling of topics on a ballot, that makes it more likely that we are going to have problems like log rolling in particular, sort of the main problem that gets mentioned in connection with the single subject rule, as well as perhaps some voter confusion that might result from the merging of these bundled topics. And so the single subject rule gets largely equated with an anti-log rolling rule. There's very little recognition or connection of how this relates back to the initiative and the initiative's underlying purpose, right? It's sort of presumed that it's bad for the initiative, but there's not a whole lot of discussion. And so the doctrine tends to sort of surface in two buckets. One is the sort of formalistic approach to subject, right? Defining it in terms of germaneness or all of these other concepts that try to formally define what a subject is. The other is kind of a functional approach that really emphasizes more than anything else log rolling. Is the initiative being used in a way that it would log roll? And if it is, then it's violative of the single subject rule. What's missing is any sort of direct consideration of the extent to which bundling topics or merging topics is enhancing or undermining the initiative. And in particular, there's very little consideration for the possibility that the combination of topics with some degree of relatedness could actually enhance the initiative. This is a logic that seems largely absent from the opinions and from the discussion on the single subject rule. And this is exactly sort of the point that I want to make, is that if we theorize the single subject rule more closely focusing on its relationship to the initiative and the initiative's underlying purpose, we're going to open up the opportunities for this possibility that bundling topics to some degree might be a way to enhance the initiative and is not always an sort of undermining the initiative itself. So now to my second point. What's going on in the world today and why is the single subject rule kind of being turned on its head? Well, the first kind of component of this is that there are some real incentives in state government today for there to be true misalignment between state government outputs and popular preferences on discrete policy issues. And so there's some great political science research looking into how governors make decisions under current political conditions. And one of the conclusions is that governors are more now than before affected by partisan policy platforms than constituent interests, and then the state's interests, sort of whatever those might be if they're separate from immediate constituent preferences. And so on issues like Medicaid expansion, the idea is that governors are acting oftentimes out of respect for party loyalty to their party than they are what their constituents would actually want and what would even be best for their state. There's also this great sort of statement related to the federal debt ceiling in 2011, where I think it was Nikki Haley, Rick Scott, and Rick Perry maybe, who all signed this like really over the top statement about how we should never increase the debt ceiling at the federal level whatsoever unless there's corresponding budget cuts. And then somebody did an analysis of what that would mean for their respective state budgets, and it was like catastrophic. And so everybody was like whatever your point is, why are you going out of the way to sign the statement when if it happened, what would you do the next day to fund your state government? And so there's this sort of general notion that state governors are increasingly being influenced by party interests and party loyalties rather than state interests and the preferences of their constituents. State legislatures can sometimes be in a similar position. And so Miriam has this fantastic paper that just shows how, for a variety of reasons, state legislatures are frequently controlled by a political party that didn't receive the majority of votes for legislative seats in that given election. And so this notion that state legislatures can often be counter-majoritarian, right? They're being controlled by a minority party. And as a result, they end up producing policies that don't align with what state popular majorities would prefer. And so there's a paper discussing gun control in Michigan, where on a sort of statewide basis, there's support for emergency relief orders, emergency protective orders, but the legislature in Michigan has not been willing to do that. And then some of the recent legislation passed on reproductive rights is kind of hard to square with some of the popular polls that are taken in those states and what people would or would not support. And then Medicaid expansion is another example where state legislatures have refused to act on that, and statewide majorities seem to be in support of expanding Medicaid. I won't say much about courts because I think we sort of understand them inherently to be in a position where they're supposed to make decisions without regard to aligning with popular preferences. But I will say that state courts have been sort of equipped in this regard through a movement, the new judicial federalism, that sort of elevated rights as a way to push back on majoritarian decision-making. There's been this push towards, I want to say, to equipping state judges, as well as just kind of a bias, I would say, in legal education that views rights, even rights under state constitutions, as performing a particular function that has resulted in state judges also invalidating popular policies that create these misalignments between state government and popular preferences. That's really only the beginning of the story, though, because in response to this misalignment, there are initiatives in initiative states to correct for the misalignment, right? And on all those topics, pretty much all those topics I just showed you, there have been initiatives to account for all of this. What's really interesting is once those initiatives pass, state government doesn't always just take the hint, right? In fact, they're often kind of annoyed by this whole sort of realignment. And so they go about finding ways to, as much as possible, not give effect to these initiative amendments. And in this paper, I sort of try to outline what I think are some of the most recurring moves that state government make. And so one of them is this whole idea of implementation sabotage, where an initiative is not sufficiently self-executing, right? It might make a change, but it's going to require, for example, funding from state government. It might require a bureaucracy and a set of regulations that need to be promulgated by state government in order for it to kind of work. And so state government doesn't like this change. And so they do whatever they can to not implement it. And so they deny funding. And some of the Medicaid expansion initiatives indicate this, where they were adopted, they expanded Medicaid, but they didn't provide for how the state's share of it was going to be funded. And so state government is like, whatever, we're not going to fund it, or we're not going to fund it unless we can fund it the way we fund it. And so the initiative is stalled and impeded in its ability to be implemented. There's another great example from Florida. In 2000, there was an initiative that required state government to build a high-speed train line that was going to connect all of the major metropolitan areas in Florida. And it's something that everybody had sort of wished could be true for a really long time in Florida, apparently. And it obviously was going to require an incredible amount of money. And so the state government initially budgeted, I think, somewhere in the neighborhood of $15 million to get the whole project rolling. The governor then ended up vetoing large portions of that funding, and ultimately the project just kind of imploded because of a combination of lapsed time and insufficient funding and a bunch of other reasons. And then this will relate to direct appeal, but then ironically the governor gets involved with an initiative to repeal the initial initiative that would require the building of the train through the state. And so there was this sort of concerted effort through implementation sabotage and then ultimately direct appeal that allowed state government officials to get around and then ultimately get rid of the initiative. Florida, incidentally, provides a lot of great examples in this regard. I don't know what that says about Florida, but, well, actually, I think I do know what it says about Florida. But another way that this is played out is just collateral attacks on initiative. So even if the initiative is relatively sort of self-enforcing and it's going to have a lot of effect on its own terms, state government might decide to implement a number of sort of parallel policies that are really going to undermine the effect of the initiative. And so, you could think in this regard, Florida had this initiative that enfranchised felons, right, and made this pathway. Well, what did the state legislature turn around and do? They're like, well, yeah, but you can't vote unless you paid back all of your fees and costs, which had the effect of carving out from those who should have been eligible to vote under the initiative a big chunk of people, and it was sort of this collateral attack on the effectiveness of the initiative. In a similar sort of scenario in Florida, there was a medical marijuana initiative that was adopted. And as part of legislation surrounding that initiative, the legislature said, yeah, you can use medical marijuana. That's what the initiative requires us to do, but you can't smoke it. You have to use it in some other way, right? And if you're a doctor and you're going to prescribe it, you have to come to this state-sponsored class that costs you $500 and takes up like a whole morning. And so they adopted all of this stuff that was essentially a collateral attack on the effectiveness of the initiative. So that's sort of chapter 2 of the story. Here's the final chapter of it all. What do initiative sponsors and groups and citizens do when they see their state government and other state governments doing this sort of stuff, right? Well, they try to craft more effective initiatives, right? They try to craft initiatives that are not going to be easily subverted by these countermeasures coming from state government. And so here, I'm just going to use one example because it's so fantastic, I think. In 2016, Arkansas adopts a medical marijuana initiative amendment to its constitution. And it's 8,500 words long. To put that in perspective, the entire United States Constitution with all 27 amendments is just over, I think, 7,500 words, right? So Arkansas's Constitution of marijuana is larger than our national constitution, right? And this was the direct result of about a decade's worth of efforts to get the legislature to adopt this, and they had put up roadblocks along the way. There had been all kinds of discussions and interactions between groups in favor of this and the legislature. So there was a very clear roadmap of what the legislature was likely to do in order to evade the initiative. And so the initiative touches on just about everything. It creates a separate agency, right, that's not going to be able to be messed with by state government. It sets up a system of ID cards for people who can get the marijuana so that there's a process in place so that they can't stymie who would be able to access medical marijuana. It regulates with great precision the way an agency would regulate the dispensaries, the cultivation facilities, how many, how they can do business, what they have to report annually, what their accounting methods need to be. I mean, it basically lays out the whole plan. It sets a timeline for implementation so that state government can't just draw this out too long. It forecasts the possibility that local government law could be leveraged by state government to affect where these places go and whether or not they could actually be cited in a feasible way. And so it has this whole section on local preemption, right? Intervening or sticking its sort of fingers into local government law and who sort of local issues versus state issues. It also provides for how physicians are going to be regulated in this whole process. The list, I mean, this is illustrative, right? This isn't even everything that the amendment addresses, but you get the idea, right? Now, this amendment is highly effective. It also probably provides a fantastic case for violating the single subject rule, right? Because with the broadening of all of these different things that the initiative is being forced to address, it's going to make it really easy for state government now to swoop in and make a single subject rule challenge. Arkansas doesn't have one as applied to constitutional amendments, and so that wasn't an issue in Arkansas, but we know that in Nebraska, right, it was with a far less sort of scattered amendment initiative attempt. The last thing that's sort of interesting in all of this is that leaving no stone unturned, the initiative also sort of imagined that the legislature might try to repeal it or make changes to it. And so there was a special carve out within the amendment rules for what the legislature could and could not touch within the amendment. And they were specific. So some of the stuff that might need to be tweaked, legislature could do that under certain thresholds, but other provisions like the actual legalizing of medical marijuana, the legislature wasn't allowed to touch. And so once again, just building the case that this is creeping into many more subjects than just legalizing medical marijuana. So what does this sort of mean for how we should understand the single subject rule in our sort of the moment that we're in right now? Well, I think for one thing, it should cause us to reconsider whether we even need it, right? So as just a policy standpoint, and there are states, South Dakota, there's states that are considering what to do with the single subject rule. It's not obvious to me that adopting the single subject rule is good for the initiative. right? That doesn't necessarily follow to me. There's reasons why it could be helpful, but the cost benefit analysis, I think, needs to incorporate some of these institutional dynamics and partisan dynamics that state government is experiencing right now to make a more informed choice if we're going to reconsider adopting or getting rid of the single subject rule. The other thing is that if we think through the judicial doctrine, I think that the functional jurisprudence, the jurisprudence that's focusing on the idea of the single subject rule as kind of an anti-log rolling proposition, I think that needs to be broadened, right? It needs to be willing to consider the fact that if the single subject rule is meant to complement and enhance the initiative, there's room for the notion that subjects could be different in some extent, but related in another. And part of what should inform that distinction is whether or not it's being used to enhance the initiative as a accountability device that realigns popular preferences with a particular discrete policy issue. And then on the functional side of things, I guess I just sort of feel like it undermines the idea of applying the single subject rule in a very formalistic way, and that it sort of emphasizes the fact that we need to be paying more attention to the purposes of the single subject rule, especially the purposes of the single subject rule as it relates to the initiative's underlying goals. So I will stop there and turn it over to Anthony to decide whether or not we have time for questions.
Yeah, this was so much fun to listen to. And forgive me if one of you touched on it and I was too busy writing notes for my own presentation, but I don't remember anyone touching on it. You know, one way in which direct democracy, you know, you're kind of overstating the significance of it is it's really no different from a constitutional amendment at the state level, right? I mean, if there are 51% votes in both settings, it's 51% votes, it's the people voting. And yes, the conventional path requires you to get legislative approval in various ways in the states. And this one is signatures, but otherwise, at the end of the day, it's the same thing. The people are amending the Constitution, and direct democracy kind of overstates, in my view, the difference. Why isn't one way of thinking about this single subject litigation, you know, they might have had 5 subjects. They're effectively amending, creating an exemption, at least for gambling or at least for marijuana, to this prohibition on, you know, more than one subject in an initiative. So it does seem to me kind of funny. I agree with you, Richard. There's a lot of good reasons to have a single subject prohibition and an initiative like that. I bought into that quite a bit. But then I just found myself going, wait a second, they just approved it. And why isn't that effectively an amendment to the amendment?
Maybe I'll just say one thing on that, and it has to go with the timing. But I was actually been thinking about that as well. They haven't just approved it. As a result of the single subject rule, that is to say the voters don't get to it, don't get to address it. For legislatures, the single subject rule isn't applied until after the bill has become a law, and then it's challenged, and then it can be struck down. For voter initiatives, it is used, as it was in Nebraska, to prevent the voters from even addressing the matter. So in some ways, it's more devastating than it is even for legislatures. Just one other thought in terms of why is it even there? I think it's there, and it's not there everywhere. It's there in about 2/3 of the states with the initiative, not all, 2/3 or 3/4, but not all, is I think on the model that voter initiatives are legislation. They're legislation as much as legislative initiatives. This comes up actually in the Supreme Court's resolution of the Arizona redistricting case, that the people of the state have decided that that the people can be a legislature too. And it seems to be a kind of just a carry along, that if we're going to require it for the one, we're going to require it for the other. I don't think it's not a complete one-to-one correspondence in every state, but I think that's probably part of the rationale. If this is going to be like legislatively adopted legislation, the same thing, the same restriction ought to apply to voters. But I think as Jonathan's comments and as my own thinking on this evolves suggests, that may be that may have been done without a lot of thinking.
So yeah, that's a great point, that you can prohibit the ballot initiative before the initiative because of a single subject prohibition.
But it has happened that the litigation has come after the vote. Florida is an example of that. And I think the Florida Supreme Court struck one. So how do you feel about that? So they get to vote, they vote on something they perhaps should not have been allowed to vote on, but hey, they approve it.
I mean, I think it just restates the problem. It also restates a problem, which is, again, I know more about the legislatures than the voter initiative, as to what happens when something is deemed not to be a single subject. Do you use severability, or do you throw the whole thing out? Sometimes with state legislation, they actually sever out the item that's seen as an add-on and leave the rest. But I think for voter initiatives, normally they strike the whole thing down, which may is consistent with the argument that this argument is being excessively used. You can get, there may be a core part, and then there may be some stuff which is peripheral, but of course, I don't look at it that way. But I'm going to pass on to everyone else on this point.
Well, and this isn't directly responsive to your question, but I do think it's really important, because part of what I hear in your comment is that what could ever supersede a public referendum? Like, if it goes to referendum, like that's the best, like that's the highest quality thing from at least a democracy standpoint that we can hope for. It's not perfect, but like it's a really high quality thing. And I think in the state constitutional tradition, we might be there now, but I don't know that we were always there. I think that the institution that carried the highest democratic credentials was the convention, in part because it didn't rely on this up or down vote, but incorporated people directly into the deliberative process in the convention, right? The whole idea with the convention is that people who weren't sitting state government officials who would have the same direct interest in the constitution making, they were the ones that were creating the draft. And so I think, at least within the state constitutional tradition, we should be a little bit suspicious of the notion that a referendum can cure all, because at least even within our own tradition, we've been skeptical of cutting the people out of the front end process of crafting constitutional reform, not just being like anybody, it doesn't matter who crafts it, right? Like, because the thing that concerns me with elevating the referendum is that it's like how it gets crafted doesn't matter at all as long as the people rubber stamp it on the back end. And I think there's been concern throughout state constitutional history that that can lead to some real problems.
Let me just make one brief point here, that we've been talking about legislators submitting measures. We were talking about the initiative measures. I want to call attention to Florida has this unique provision where a constitutional commission comes about every 20 years. It really comes about every 10 years because they have two of them, and it can propose measures directly to people. And the Constitutional Revision Commission in Florida is not subject to the single subject rule. I'm generally suspicious of single subject rules because I see the way they can be manipulated. Oftentimes does seem to line up with the judge doesn't like the underlying subject thing and it gets struck down. But I learned to like the single subject rule in its absence. Florida in 2018, their Florida Constitutional Commission, they combined the most unrelated things. They said, okay, we've got basically 27 changes and we're going to put them in 9 sets of 3. And so when you were voting on judicial related changes, you would be voting at the same time on, do I want to prevent the state courts from deferring to administrative agencies? Do I want to change the judicial retirement age? And do I want to deal with something concerning kind of victims' rights? All or nothing in that sense. Now, it's true the voters could just simply push back. It's like, I'm not going to fall for that. But it did seem unfair to voters who might have wanted one or the other of those to not have a chance to say, you know, I'm really excited about preventing judges from deferring to administrative agents. Sign me up for that one. But I'm not on board with this judicial retirement age one. And so in seeing what this kind of this Constitutional Revision Committee in Florida, just crazy stuff, I said, you know, I kind of wish they did have to be bound by the single subject rule. So by seeing the outer edges to which that was put, I learned to love it a little more than I did.
And I would just say that example is so scary because the commission's not a convention, right? Like they're bundling things up. If a convention with higher democratic credentials, even than a legislature, is bundling things, which is usually the case. It's often, sometimes those votes from a convention proposal will be split up, but oftentimes they're consolidated in ways that don't make a whole lot of sense. That feels safer to me than just sort of a referendum without regard for where the proposal originated.
Just an asterisk on that last conversation, John's point. It connects to a doctrine in California, which distinguishes between the constitutional amendment and constitutional revision, so that voters can initiate an amendment, but they can't initiate a revision. And so it's a kind of a backward single subject rule. So I think that came up actually when the early cases involving Proposition 13. Proposition 13 made multiple tax changes and spending changes. And one of the arguments against it, which failed, was that it went beyond an amendment in terms of, and became a revision because of the way in which it changed the balance of power between local governments and states. And I think this is a doctrine that California courts do follow in dealing with very sweeping voter initiatives. Is the question whether or not it's an amendment or a revision. Sorry, go ahead.
So I have a question about the relationship between the people and legislatures that I think everyone has touched on in to some extent. Do you see a case for a stricter application of the single subject rule when it applies to constitutional amendments, but one that's closer to a liberal single subject rule that would apply in the context of a legislature when it applies to statutory changes? And is there evidence for that around the country, either in the way they're written in constitutions or the way that courts apply those rules in a constitutional context versus a statutory context?
Well, again, there's sort of two kinds of constitutional amendments, right? The ones that come out of the legislature and the ones that don't. I don't think single subject rules apply to the legislature's generated constitutional amendments. And so there it's really, you've got to, they can put together different things in the same amendment. And then say it's all on the topic of criminal justice or tort reform or something. And then it goes to the voters. I think it might be a different issue with respect to voter initiated constitutional amendments, where again, you get something like the California doctrine, the distinction between an amendment and a revision. But I'm not that familiar with the cases dealing with pure voter initiated constitutional amendments.
So in Nebraska, we have a distinction in our initiative provisions that allows for the voters to initiate either a law or a constitutional amendment. And I think that's what Andy was getting at. We also, just to Richard's point, have a provision that requires separate presentment of legislatively proposed constitutional amendments. And that too has generated something similar to a single subject rule that's part of our broader doctrine. But I think the question was related to, is there room for perhaps, given the history or the practice in other states, for having different single subject rules depending upon the subject matter that the initiative process is generating, specifically legislation versus a constitutional amendment, both of which have much different parameters for subsequent change.
So I don't have a direct answer to that because I'd need to look at some of the more case law in that sense. But the one thing I would say is that we do make distinctions throughout states in terms of what's required to get a initiated statute versus initiated constitutional amendment. And so in many states will require a higher level of signatures to be required for putting an amendment on the ballot rather than putting a statute on the ballot. Some state, Colorado said, well, we'll have a kind of a geographic signature distribution requirement for the constitutional change, but not for the legislative change. So it wouldn't be that big of a stretch to say that we might have different rules for single subject for the initiated constitutional amendment from the initiated statute. I guess that's my only point. That would certainly would follow from other distinctions that we'd made in American state constitutional law.
So one of the things Jonathan was talking about was that in some states, the political branches are undermining the effect of the state referenda in various ways. And one of the themes of Miriam's talk at the outset was that democracy is an overriding principle in a lot of these state constitutions. So I'm wondering if courts have ever stepped in and tried to, in some way, tell the political branches, you can't thwart the democratic will as expressed in these initiatives in the way you are, or if there's just not a mechanism to compel the governor and or the legislature to fund a Medicaid expansion that they don't want to do, or not undermine in other ways.
John might be able to fill in some of the details. I only have vague recollections of this, but I think the point that you're making has manifested in case law, and Oklahoma comes to mind. So I think that there's some decisions from Oklahoma where they've been incredibly protective of the initiative and legislative encroachments on the initiative. And it's been because of the conceptual weight of majoritarian rule and its connection to democracy devices. I wish I could remember the details of the cases and the issues, but I'm fairly confident that that has come up in the case law, especially in Oklahoma.
Anthony, thanks to you and everyone at Nebraska. I'm also sorry I can't be there. It's just a real privilege to be able to continue conversations that I was thinking back to. I think back when I was in the Attorney General's office processing initiatives and defending them and challenging them in court was when I first met John Dinan and started talking about some of these issues, and Richard as well. It's really great to see, and of course, Judge Sutton, who's been out to Montana, hearing from Miriam and Robinson and Jonathan on these also. I'm just really looking forward to diving into this work. I am intending to sketch out a paper here, and so I'm going to encourage lots of questions. Feel free to put them in the chat. I'm also going to set a timer. Okay, so this is a picture of the Montana Capitol, a version that was never built. I guess they ran out of money to make it look that fancy, but attention to the all those people on the outside trying to participate in the process. I thought that was a good study of direct democracy. My focus is going to pick up on a lot of the themes from this morning about interference, we might say, or encroachment upon direct democracy and powers reposed by state constitutions and the people. And I'm going to propose first discuss the unusual kind of constitutional vulnerability of direct democracy. The initiative can't defend itself in the same way that standing bodies can, the executive branch, the judiciary, or the legislature. After looking at a couple of the possible lines of defense for direct democracy in the states, I'm going to turn to some models of separation of powers, talk about some pluses or minuses of adapting separation of powers framework in particular models in defending direct democracy, or at least beginning to wrestle with some of these issues, and then propose some problems that separation of powers framework might be able to solve at least as well as some of the other approaches that have been suggested. And then I'll finish by maybe suggesting some other knots that separation of powers view can help unravel. So first, I think, and we've seen this, see Supra, everyone who's gone before, there are lots of fronts of attack on direct democracy in the states. And which is kind of curious, because if you read state constitutions, and it's been nice to have the opportunity to read Nebraska's constitution, the direct democracy is at least as entrenched as any of the other powers conferred by state constitutions. Right? In Nebraska, they talk about how it's independent of the legislature, not language that every state constitution has, but these sorts of provisions are common. The first power reserved by the people is the initiative. And, in Nebraska, and this isn't true of many states, it's not true of Montana, but there are actually limits in many states in terms of the legislature's interference with the product of direct democracy, a supermajority vote, and sometimes time periods that have to pass before the legislature can revisit an initiative. And the idea that there are detailed provisions that are codified into constitutions, so that in many states, the Constitution isn't all you need, but it gets you most of the way there towards figuring out rules over signature requirements, for example, distribution requirements, the petition process, the fact that the full text of the petition of the proposal has to be on the petition, et cetera. And so the constitutions try to entrench direct democracy in a way that might leave less room for legislative interference, particularly compared to some of the other separation of powers issues that arise in much broader, simpler, more vague vesting clauses. So Yet we see, and this has been discussed already today, we see judicial fronts of attack on the initiative power through the single subject rule, executive fronts. Jonathan talked a little bit about this, and it's something I'm also interested in. The failure to okay initiatives by the Secretary of State, sometimes the failure to defend initiatives by the Attorney General. Sometimes the Attorney General is involved in the balloting process, and really tricky questions about failure to implement. I'm going to focus today, though, on really what John Dinan teed up so well, the legislative front of attack on the initiative process, which I think presents some of the trickiest issues of sorting out what sort of interference with the initiative process is authorized by state constitutions. Our legislative session here in Montana was all sorts of experimentation in our laboratory of democracy about direct democracy this session. A new rule that allows the Attorney General, or requires the Attorney General, to note on petitions whether he views the initiative as harming one or more business interests. And of course, the Reclaim Idaho case that Miriam introduced earlier, where by statute, the legislature expanded the distribution requirements for petitions from 18 to all 35 legislative districts. We also see these challenges from the legislature happening on substance. Again, we've seen statutory single subject requirements. Again, here, Montana worked to further define, we have a no appropriation rule that's in our Constitution. Generally, I'm not going to worry about those today, but then the legislature attempted to define appropriation in a way that the courts have not, to say that any expanded eligibility for a government program would also constitute an appropriation. So substantive challenges, saying that certain issues are on or off the table for direct democracy, or changing the requirements. And then finally, we have the modification after the approval. South Dakota had its Measure 22, an ethics reform measure, repealed by an emergency session. So it tells you something about direct democracy, that ethics reform for legislators is enough to cause a state of emergency, justifying them to repeal such ethics reform. And of course, as John and others have indicated, the Medicaid and marijuana provisions, and Jonathan's story about Arkansas, I had not heard that yet, and that is a really interesting story. So lots of after the fact tinkering and modifications. So those are the sorts of assaults. And I don't mean to be too militant in terms of the initiative, but those are the sorts of problems, right, that the legislative branch can cause the initiative process. How should we start to think about those? Well, I mean, there have traditionally been a few models. There have been federal rights. So for example, we'll often see around signature gathering, non-resident signature gatherers, for example. And there's campaign finance restrictions. We can see those as potentially framed as legislative attempts to limit the initiative process. All I'll say about that is I wouldn't expect the court, other than outside of the campaign finance area generally, to be particularly protective of direct democracy in the states. This was on a grant of a stay in a precursor to the Idaho case. Four of the justices were very clear that they're going to be quite deferential to state regulation of the initiative process. And there are all sorts of ways in which the First and 14th Amendments principles are both over and under inclusive of the kind of concerns that Miriam and Robinson introduced theoretically for why we value direct democracy. Well, what about state rights and the state framing? And in part, and I certainly don't mean to mistake, I agree and concur with everything Miriam says about the need for a democracy principle. I think there's a problem in terms of operationalizing it. And without getting into the full Hofeldian analysis of the relationship between rights and powers, It is just a little tricky, isn't it, to have a statement that says because that powers are fundamental rights and then do strict scrutiny. I'm not sure that's the right framework here, particularly where we have, as the state constitutions themselves remind us, that the initiative power is a power. I mean, we can see that that power is reflecting the Article 1 sovereignty provisions, often Article 1, Section 1, Article 1, Section 2 of state constitutions. But what we're really talking about is powers, and at least where federal rights and state rights may be insufficient to protect direct democracy against legislative encroachment, I think the natural approach is separation of powers. The devil's in the details, though. So what are we going to do about that? Well, of course, state constitutionalists know that unlike the federal constitution, state constitutions put separation of powers right in there. This isn't some overarching principle. It is in the text of just about all state constitutions, dividing it. And that is helpful in some ways if we think about the initiative power as being a legislative power within the legislative branch, the legislative department. If we're talking about executive encroachment, as we've seen, or judicial encroachment, as we've seen. The problem is that this state formalist model, where we can view these as vesting clauses in some ways, doesn't work for the initiative power, because if you're talking about legislative encroachment on the initiative power, they're both within the legislative branch. So we need some other model that goes behind the textually grounded formalist model that we see at the federal level and see in other contexts at the state level. So what does that look like? What other models of separation of powers do we see in the states? And this is certainly an incomplete list. I look forward to discussion or suggestions. Reach out to me if you have other ways to do it. But you know, a cursory glance at the state separation of powers literature suggests there are a few different pieces. And of course, I'm like we all are, I'm indebted to Judge Sutton for his most recent book on Who Decides, which frames up some of these really well. There's the kind of idea that it's a fourth branch, that the people are kind of a fourth and superior branch to all of the branches, and that's true to some extent. But that's not the way that the people's power is framed in the initiative power, so not a perfect fit. There's bicameralism, with apologies to Nebraska, and there's the plural executive. I think these all have things to offer, but I think the plural executive might be the most, in some ways at least, the most productive frame for this. But let's take a look at all of them. So this idea of the fourth branch, this is something in the state constitutional tradition we see in discussions of more or less agency independence, boards of education, boards of regents. And yet we see I think in general, in many of the cases, we see that courts probably properly reject these sorts of fourth branch claims, that you could have a branch outside of the branch that the separation of powers provides. There are only 3 distinct departments. That's what it says. You can't have a fourth branch, even if there might be divisions within a branch and autonomy within branches. So it's not at all a perfect model for this. And yet we might draw some separation of powers principles here that can help us in defending direct democracy against legislative encroachment, and some of the autonomy and non-delegation principles. So for example, if you're dealing, as fortunately we have here in Montana, a relatively autonomous board of regents over the state university system, well, you'd ask, well, if the legislature can't limit the subjects that I teach in the classroom because the board of regents is an autonomous part of the executive branch, why could the legislature dictate initiative subjects? It's imperfect, but it gives us something to grab onto. Or if we think about the non-delegation discussion, and Judge Sutton has a great chapter on this in his new book. Well, if the legislature can't delegate its legislative power to the executive, why would we assume that when the people have and share the legislative power, that they can delegate their power over the qualifications, distribution requirements, and other things in the Constitution? Why would they be able to delegate their authority to another part of the legislative branch? Those are some of the questions that might be helpful here. But again, I don't think that the fourth branch approach is the best way to look at this. So what about bicameralism? And yeah, whoops, we're in Nebraska. So I'm going to come back to Montana for this one. Bicameralism, I think, also is helpful in some ways. Because there you do have a division of the legislative power. The problem is that the division of the legislative power there in bicameralism is they're codependent. They're not independent. And yet, even right, despite that codependency, we see well-established constitutional rules that say those codependents still can't encroach upon each other. One house can't impose its rules and qualifications on the other. Each house shall promulgate its own rules and be the judge of the qualifications of its own members. If that's the case, even within the legislative branch, why would we expect that those two branches acting together could impose additional rules and qualifications on the people in the conduct of the initiative process? We also see another analogy might be the constitutional officer qualifications cases where the legislature attempts to supplement the constitutional requirements for various officers. Right? We can think of that in terms of, again, in terms of distribution requirements or signature requirements. All right. My kind of main contribution, I hope here, is to think about, well, maybe one thing we can do with state legislatures and direct democracy is to understand that just as we have a plural executive, as Nebraska has, we could have a plural legislative. And actually, I think the arguments for the parity of the people through the initiative process in the legislature are even stronger in a plural legislative model than they are in the plural executive model. Just look at Nebraska's constitution. This isn't true everywhere. Montana's is different, but the Nebraska Constitution actually makes the governor supreme. The legislative authority doesn't say anything about the legislature being supreme to the people with respect to that. So that might, and in fact, it reinforces its independence. So I think if we think about the plural legislative, we might get a few helpful ways of thinking about separation of powers problems in direct democracy. First, even more than executive powers, for example, the often debated role of the attorney general vis-a-vis the governor in state government, we're really dealing with general vesting clauses there. They don't tell us much, and yet I don't think we have much of a problem in terms of conceptualizing some of the core duties of the governor and the attorney general. Well, it's even easier and more straightforward to conceive of a plural legislative when, as we've discussed, the initiative power and the rules governing are generally far more entrenched than any of the general vesting clauses for executive branch officers. So we've actually got more to work with in a plural legislative branch than we do in a plural executive branch about the allocation of authority. I love this in Nebraska. We don't have this in Montana. One of the things I want to ask is how common these sorts of necessary clauses are. But of course, here we have the idea that the legislature has a duty to the rest of the Constitution, including the people. That's not something that we see at the federal level. State legislatures have all sorts of duties with respect to school funding, with respect to other areas. And so that gives us more. The governor and the attorney general, sometimes the attorney general has some duties to the governor, but here we have a nice setup to try to understand what the legislature owes the people in the initiative process. And one more thing about the plural executive, at least plural legislative, is that we actually don't run into some of the same concerns we would run into in the executive branch. Legislative powers and executive powers can be concurrent. We've seen this. But there actually is kind of less likely to be the direct conflict that we would see in a plural executive. What do I mean by that? Well, this is an example that Judge Sutton uses, and it's come up a lot. It's certainly any of us who've worked in state government have experienced this. The attorney general and the governor take opposite sides in a case. Well, they're both able to assert different interests, one on behalf of the state and one of the agency, Usually courts have said, okay, that's fine, right? Even though they're taking inconsistent positions, the administration is conflicting and concurrent. That is one thing that can't happen with the legislative power, because the law, legislation, the resulting product is unitary. It might be sequential, there might be a battle back and forth, but you're only going to have one code at the end of the day in terms of the effective law that's the product of this process. We can imagine checks and balances playing out that are actually simpler to resolve, at least sequentially, than you see when a governor and attorney general are conflicting at the same time. That can't happen with the lawmaking power. So putting that together, here's at least a first crack at an approach to this, is that we'd say that, and this is important, much of what John and Jonathan have talked about, and some of what Richard worries about, is constitutionalized. I'm not worried if it's in the Constitution for now. It's not an issue. What I'm worried about is the conflict between the legislature and the initiative process. So unless the Constitution grants or denies a specific power, the legislature has a duty to implement, but cannot encroach upon the initiative power. That's the key separation of powers principle. Subject to the power, just as we see in other separation of powers pieces, of each to check the other through the ordinary powers of legislation, initiative, referendum, and repeal, at least as permitted by the state constitution. Right, the devil is this idea in the details, is this idea of what does it mean for the legislature to have to implement it. Obviously, in order to have an initiative process, the legislature has to be involved to some extent. How are you going to measure interventions that support the initiative process versus interventions that encroach upon the initiative process? That's at least the right question to ask. And I'm not sure how we should frame that. Maybe it's a question of faithful execution. Nebraska's necessary seems like a good place to start. But I do think that that's the right question to ask. If we ask that question, I think it starts to clarify some of these problems that arise, just as the Idaho case suggested, using a rights rather than a powers analysis, the legislature can't, it can execute the initiative power, but it can't contradict or undermine the requirements there with its own additional provisions. For example, if you have constitutional distribution requirements, the legislature can't add to those. Substantively, the legislature can't control the substantive initiatives by statute, right? So a legislated single subject rule, I think, would be unconstitutional under this. It would encroach upon the power. It would have to be put in the Constitution itself. And the modification is that the legislature, the part of the deal is part of the checks and balances, that the legislature can come in and modify initiatives through repeal, and we'll hope they're accountable. Not perfectly accountable, as Miriam and Jonathan's work has suggested, but that's ordinary, and that's not a separation of powers concern. That's a feature, not a bug. Remaining puzzles here, I'll just leave you with. So I'm not sure how separation of powers frame would handle election integrity rules like signature verification and gatherer rules. You could see that in two ways. You could see the legislature say we're banning payment of signature gatherers because that corrupts the process. And I think there are good arguments to be made there. I've made some of them in court myself. But it's not clear that that's always going to be the case. Some of it may well be, and certainly that many proponents of initiatives would suggest that that does encroach upon the initiative power. Also, the voter information, the idea of harming business interests, that strikes me as probably getting a little too detailed into the particular subject. But what about general petition and ballot statements? What about discussing the fiscal impact of ballot statements? Those may be less problematic and might be viewed more as fulfilling the function of direct democracy rather than encroaching upon it. Substantively, what do you do with legislative liquidation of constitutional terms, like Montana's definition of appropriation, some of the legal sufficiency review language that many states have? Relatedly, what are you going to do with judicial interpretation of single subject rules? I'm not sure that the separation of powers analysis adds much to that. Modification. Well, what about legislative loopholes? I think the South Dakota emergency over ethics reform is one example to keep an eye on. What about executive failures to implement? I think we would expect that a governor should take care to faithfully execute initiated law as well as legislative law. But again, I'm not sure that separation of powers is doing most of that work. And then finally, what about initiated statutory restrictions on initiative power? Part of my premise here is that the people, through constitutional amendments, because that's the people's document, can limit and restrict the initiative power. John Dinan had lots of examples of that happening. This has nothing to say about that. What about the people through an initiative process, if they restrict their own power through that by statute or through a referendum? I'm not sure that this is as helpful with that. What else? I'll just note this quickly. This has come up in a few different places this morning. Maybe looking at the initiative power through more of a powers rather than a rights lens will help us, might add a little bit to the legislature election clause, the independent state legislature doctrine. I think with respect to the single subject rule, it might at least suggest that there should be parity of a single subject rule. And as I noted before, that a governor would have the same duty to take, it is not off the hook because it's some initiative. The governor has the same duty with respect to initiated and legislated laws. And finally, and I think what I'm most interested in exploring as this takes shape is whether there are lessons from the plural legislative branch that can reinform and come back to the plural legislative branch. I'll end for now and turn it over to the judge.
Thank you to Nebraska Law School for inviting me, and Anthony Johnston. It's fun to share the stage with you and harken back to our days in the AG offices. I see our perspective, and in particular mine, experiential thoughts I have based on my experience working as the SG of Ohio and perhaps a little bit as a judge. So I guess the way I'm looking at it is, who checks the people? Put another way, are there ways in which indirect democracy can check or should check direct democracy? So let me start on the federal side. Got I guess a slight bias as a federal judge. Are there ways in which the three key federal branches can check democracy, either historically or going forward? The U.S. Supreme Court famously upheld direct democracy in a 1912 decision coming out of Oregon, out of the Oregon Supreme Court. The challenge to the initiative process in Oregon was based on the Republican form of government guarantee, and the claim by this telephone company, which they were opposing a tax that the state had imposed on this telephone and telegraph company, was that direct democracy, whether through referenda, amending a statute, or changing a constitution, didn't really matter, violated Republican form of government guarantee. How could it be Republican government to have direct democracy? Chief Justice White made short work of the challenge, said, listen, we have this case Luther versus Borden. We said this is a political question. It's not judicially enforceable. If anyone's going to check direct democracy, non-Republican governments, it would be through a Congress. That still leaves U.S. Supreme Court federal law opportunities to check democracy, direct democracy, but not structurally, not systematically, but law by law. We actually have quite a few of those, many of them quite famous. If you think of Romer versus Evans and Obergefell, marriage equality, anti-discrimination laws, those are both situations in which the U.S. Supreme Court checked direct democracy. You have Schuette's, another pretty famous case where a pretty controversial issue. You have the state of Michigan, like several other states, passing initiatives that prohibited affirmative action, whether in universities or allocation of government goods and services. The challenge to that was again on the Equal Protection Clause, but that one failed. The U.S. Supreme Court permitted that change in Michigan law. So that's the U.S. Supreme Court. Congress, well, I already mentioned Congress, Republican form of government guarantee. I think most people would assume that means at the stage of which a state enters the union, that's the time to check. And when you're looking at their proposed constitution, I don't think too many people think of Congress having the authority to suddenly check a state initiative process based on the Republican form of government guarantee. Who knows? But I don't think that's the way it's thought of traditionally. That still does leave other significant options, again, like the U.S. Supreme Court, not systematically, but law by law. And the key point there is the Commerce Clause. And historically, the U.S. Supreme Court has given Congress really wide berth when it comes to the Commerce Clause. And as long as the underlying a legislation deals with something that substantially affects commerce, the odds are quite high that the court is going to uphold that congressional law. How could that apply to initiatives? Well, legalization of marijuana is a really good illustration of this. In fact, it's filled with ironies. In a case called Raich, the US Supreme Court said that Congress could pass these marijuana possession prohibition laws. And in the Raich case, they were able to enforce it against Angel Raich, who was growing marijuana in her backyard, not for sale, only for consumption and only for medical use in a state, California, that prohibited sales of marijuana. You would have thought that did not constitute commerce. The US Supreme Court said it did constitute commerce. So theoretically, laws like that are laws which Congress could come in and prohibit any legalization effort, because one of the things people sometimes wonder why these Commerce Clause cases are so significant. The power to regulate, the congressional power to regulate, is the congressional power to preempt. Anything Congress can regulate, it can preempt, which is to say nullify any state lawmaking in that area. So theoretically, after Raich, Congress could come in. It didn't happen under the Trump administration. Don't think it's going to happen under the Biden administration. Probably not going to happen ever. But theoretically, that's an area where you have quite a bit of initiative activity, and it could be wiped out by an administration so long as Raich is good law. So that leaves the presidential power, executive power on the federal side. And that, again, relates to the Raich story. Wonderful illustration. We still have those bans on possession, distribution of marijuana in federal law, but they've not been enforced by the executive branch. Executive branch has that authority. They get to pick and choose what laws, criminal or civil, to enforce, what laws not to. And we have two administrations that have not enforced these laws on the books. And it's very significant when it comes to those initiatives. And the same could be true with any other initiatives that potentially substantially affect commerce. I have to say, that's a lot of them. Not all of them, but a lot of them for sure. So now let's go to the state side. Again, how can indirect democracy check democracy? How can representative government check direct democracy? And I'll start there with the state court angle. And the key one today, and seems like the center of the program, is the single subject clause. I'd be really embarrassed if I had nothing to say about this. You'd say, why did we invite him? So I have quite a bit of experience in the single subject clauses. Of course, never heard about them in law school because state con law was not taught at Ohio State. But pretty early in practice at a firm, Ohio passed a pop tax. They were trying to find a way to fund their public schools more equally. The main reason being that I lost a challenge to the Ohio school funding system. That was my first $35 billion loss. And poor Governor Voinovich had to find a way to fund this. And they were doing all kinds of things to try to create more equity in public education. One was a penny a can pop tax. Pop would be the way you refer to soda or sugary drinks in Ohio. And the challenge was it was part of an appropriation bill. I'm in private practice. I have a client. I got to tell you, I thought the single subject rule should be vigorously enforced at every turn. Now, of course, I had a client paying me to say that, but I'm just telling you, in my state of mind, I thought it made so much sense. Fast forward a few years, I'm on the other side of the coin. I'm representing the state and defending a challenge to the Ohio vouchers program. So Ohio, City of Cleveland, City of Milwaukee were the first two states to have pilot voucher programs. They were attacked pretty quickly under federal and state constitutional grounds. A single subject was one of the lines of attack against the Ohio voucher program. In that case, the voucher program looked a lot like a rider, what Richard was talking about earlier. It was the biennial appropriations bill, which is something that really does have to be passed. Ohio, unlike, say, Delaware, does not have an exemption from the single subject clause for appropriations bills, so it was a legitimate attack. And the voucher program, which clearly was controversial, was added to the bill towards the end. I got to tell you, when I was on the other side, representing the state, I thought these single subject clauses were ridiculous and they should never be enforced. So it makes me very skeptical of anyone who knows exactly how to do this, because I've been on both sides of these and I thought opposite positions were completely right. So yeah, well, as an advocate, of course, now I'm a judge and now I'm Mr. Objective, but I will say in defense of what would, this is the key thing I wanted to mention from looking back at that vouchers experience. There was something to what the Ohio Supreme Court did. So that case, the vouchers case, mainly had challenges based on the Establishment Clause, because the Ohio voucher program was going to permit these vouchers to be used at private religious schools and private non-religious schools. So you had state and federal Establishment Clause challenges, the state ones through our Blaine Amendment. We had a Uniformity Clause challenge and then the single subject challenge. Now, the Ohio Supreme Court at that time, as I learned with all of my losses there, was a court that was pretty friendly to constitutional innovation in general, quite open to construing their state guarantees in a muscular way. It's elected judges in the state, plenty of fundraising in these races. And it was definitely a majority of the court that had union support, which would have included teacher union support. My big fear in the case is I really thought it likely that they would invalidate the law under the state Establishment Clause, the state Blaine Amendment. But they did not do that. All they did was invalidate it under the single subject clause. So what was going on there? Now, of course, I don't know. This is utterly speculative, and it's coming from the loser in the case, never a person to trust. But looking back on it, I found myself saying it kind of made sense. Vouchers are complicated. They're not complicated for a teachers union, but they are complicated because if you look at the Cleveland voucher program, there was a lot of good behind it, right? This was one of the worst public school systems in the country. As an advocate, I said the worst public school system in the country for emphasis, but no one was disagreeing that it was a failing public school system. It didn't seem like a terrible idea to have a pilot program for 5,000 families to give them a choice. And I suspect the four justices, it's a 7-member court, I lost 4-3. I suspect the four in the majority were not comfortable putting a complete stop sign on vouchers in Ohio, even though this was a group that I think was sympathetic to teachers unions. I think it just made it a hard case. So what did the single subject clause allow them to do? Instead of a red stop sign, you might argue a yellow sign. It allowed a process-based ruling, not a substantive objection to the underlying program. And there's some, I wonder if that doesn't motivate some state courts. So in other words, instead of being deeply skeptical, they're just voting their worldviews. There's a reason for a single subject prohibition that you're not substantially saying never. You're not saying to the people of Nebraska, you can never do this. You're saying this instance, in this way, it's not going to work. And it's worth pointing out in the Ohio experience, that actually is what happened with vouchers. So I lost that case. You know that I lost all these cases. But within a month, they passed a new bill, and it was an education-only bill, still pretty broad, but education only. This is back to Richard's point at the level of generality, but no one challenged that. And so, you know, I realize a process-based single subject objection because of circumstances in a state and the politics of the state may mean it'll never get done. This is not lost on me, even though I'm a judge and not a political scientist. But I do think it's interesting that that is one benefit of single subject clause challenges. The process-based, the legislature can return. It's not a complete and final check on it. I will say more generally that I am skeptical. I mean, Richard lays it all out. I just find it so hard to figure out what to do with these things. I find the remedy thing incredibly strange. They almost always, when they find a violation, just pull out the controversial item, the one that's challenged. But if this is process-based in the sense that it's essentially, they're saying it's corrupt legislation, the only way you got the votes to pass the bill was these bargains which the single subject clause is supposed to prohibit, that suggests the whole bill is tainted, every feature of it, even the first subject. But no one seems to have the courage of their convictions in doing that. So I find the remedy quite strange. And I do find it really difficult to figure out how to define subject, particularly when we're talking about the legislative situation. And, you know, I get that in America circa 2021, it sounds very strange to say, why don't we just let legislatures enforce it? You know, people start using metaphors like foxes guarding chicken houses and so forth. Well, how good do we feel about judicial enforcement would be my first response. It's very uneven. It's very hard to find principles linking all these cases. And so if you're going to have haphazard, uneven judicial enforcement, which brings disrepute on the courts, why shouldn't we just be relying on the legislature and let the politics win out? In the politics, I was talking to Professor Dinan, who's done so much great stuff on this. The Florida experience. So Florida does not have a single subject prohibition on initiatives, but they had, he was referring earlier to how the commission, Constitutional Reform Revision Commission, was bundling unrelated provisions, 2 or 3 per vote. And some of them were just really weird. So it's just so strange for the citizen to have to vote for the thing they really want, but have to bring along something else. Like, can you imagine, you know, gambling and legalization of marijuana? It's like, my God, which is more, you know, this is what the Battle of Stalingrad, you know, whom do I hate more, the Nazis or the communists? You know, but then that's easy. You just say no. What about if you like one of them? It's the Allies versus the Nazis. Now what do you do? That's people of Florida, after that experience, put on the initiative. You just got to love this. They had an initiative to get rid of the commission, which grew out of their frustration with bundling, which sets up my point. The people are not fools. When they see games being played, they respond. Now, it didn't pass, partly because they've inoculated initiatives by requiring 60% vote to amend the Florida Constitution. But it was a close vote, and it was close. They didn't even get over 50%. I think maybe they got 48%. But that's a lot. That's a very big vote based on bundling. So that makes me think, why are we so sure that people can't respond to legislators playing games? You know, back to my theme in life, why do we need judges anyway? I gotta stop this. This is why I go to law schools as opposed to judicial conferences. I suppose I haven't got an invitation in a while. All right, so let's just go to a couple other options. I'm not going to cover. Anthony covered perfectly the way the legislature can be checking the initiative, and I think there've been a couple people that have observed the complications of that. I do think the plural executive is super interesting at the state level as another checking mechanism potentially. And the plural executive is just so fun because you not only have separately elected governors, AGs, and Secretary of States. Those would be the 3 ones most likely to care about direct democracy and initiatives. You have plenty more in most states. They're separately elected. They have their own mandate. That would be significant even if all 3 were from the same political party. That could still lead to disagreement. It could be illegitimate disagreements such as ambition, who wants to be US Senator or whatever it might be. And it can be more legitimate, you know, just a different worldview. You might be from the same political party, but have a different view about the underlying proposal that the initiative is taken. But think of how much more complicated and rich it gets when, as is permitted in all these states, the separately elected executive officials come from different political parties. So that can really be fun and interesting. It can lead to quite legitimate efforts to slow down, create restrictions on exactly how an initiative looks, and perhaps illegitimate ones. One that I think is largely legitimate, maybe in the questioning, see if people agree with me. Secretaries of states, this isn't always the case. Sometimes attorney generals have a role here. But in Ohio, anyway, it's usually the Secretary of State that deals with approving the ballot language. And sometimes the AG will get involved. And the point is to make sure it's clear. So that is a slight restriction. So you can have some citizens initiating an initiative. They get the signatures. It goes to the Secretary of State's office. And the Secretary of State still has a role to make sure it's presented in a way that's fair, even-handed, and semi-coherent for the voters. And I guess by and large, I've thought that's fairly untainted. Sometimes people complain that they're putting things in positives when a negative might make it easier for a vote in one direction or the other. So perhaps that counts as a slight form of game playing. But for the most part, I don't consider that problematic, based at least on what I've seen. I will tell you one story from state government, and since I think that's my role here, the experience-based approach that should make one cautious about thinking doctrine and high political theory is the way all of this operates on the ground. There's a story that I think is true. It could be apocryphal. Heck, since it's apocryphal, I'll say it involved an initiative, but I don't think it did, but let's just stick with the apocryphal side of the story. So the governor and the AG in Ohio were from separate political parties, had separate political agendas, and they had a serious dispute about what the position of the state was going to be in this legal dispute. I don't think it was actually an initiative. I think it was actually a fight about defending a state law. And that's an interesting fight, right? As a matter of state constitutional law, the AG is the legal official in the state. You think that gives he or she gives them quite a bit of authority. On the other hand, the governor has a lot of power. The governor has a very big say in the budget. That's a budget that would affect the AG's office. The governor has all kinds of appointment powers. So if you happen not to win your race as AG, you can be put on commissions, keep your years of service. So the governor, even though they're just another separately elected member of the executive branch, is a first among equals. So it's a pretty powerful clash when you have a debate about what the legal position of the state is going to be. So they go back and forth. The governor saying we should do this, the AG saying we should be doing this. And finally, the AG says, okay, governor, you win. I'll send you a lawyer over in 15 minutes. The AG goes back to his office. The AGs in most states are the biggest employers in the state of lawyers. And so he looks over the 500 lawyers working for him, finds the youngest, greenest, goofiest looking guy he can find in the office, sends him back and just gives him a legal pad and says, the governor wants to see you. So this poor guy's probably been on the job a week. And he shows up at the governor's office, knocks, and the governor says, who are you? The attorney general sent me to see you. Takes one look at him and says, could you wait outside? Governor gets on the phone, calls the AG and says, you win. Doctrine can be overrated as to how we determine the legal position of the state, separation of powers, and all of that. I often think this is how it really plays out. So two last points. One is really quite half-baked, but it just interests me to think about it. What is going on with the initiative? What are we really doing? And it's kind of consistent with some other things going on in America, which is we're outsourcing government in a way. We're privatizing government. We're saying the people get to do it. This is kind of what it means. The initial point of it was a progressive point to check legislatures that had become captured, usually by one industry, but sometimes several. So it could be the railroads in one state, could be banks in another. The critique of the initiative, the thing that is making people nervous about the initiative today, is this ironic development that it's the powerful, the moneyed, that are most likely to be able to use the initiative productively. And I think that's what sometimes makes us nervous with modern uses of it. There is no doubt money's going to help you get the signatures, and money's certainly going to help you with advertising, whatever else is needed to convince 51, 60%, whatever it is, to vote for it. I wonder if the answer is that we should be a little more hopeful, and the more the initiative gets used, the more we should assume that in a weird sort of way, the market's going to work its way through on this, market in political and money terms, that the more the initiative becomes a way of doing business politically, this outsourcing of government, the more it seems to me other moneyed groups, whether corporations or not, are going to realize the force of this development. And it's almost like an adversarial system in litigation. You have a real adversarial system when it comes to initiatives. So it's really a half-baked thought, but I do wonder if that's a partial answer to the problem. of the irony that this was designed to check moneyed industry that had captured legislatures, and now they seem to be the greatest beneficiaries of it. I guess that's maybe a little bit hopeful. My last thing in terms of reform is, and I do feel quite strongly about this, one thing I'm almost contemptuous of when it comes to initiatives is they really give state constitutions a bad name. So, and a bad look for sure. So many state constitutions really look like they're codes. They're addressing topics that seem more suited for legislation, and they're writing about the topics. See the Arizona marijuana legalization. They're writing about them in ways that really look very legislative. And so you're breaking down what I think is a very important distinction between statutes and constitutions. You constitutionalize everything, you end up constitutionalizing nothing is the risk. And I do think initiatives, it's not the only source of this problem, but initiatives have been a very big source of this problem. And I do think one quite foolish feature of many state constitutions is to say that the rules for a referenda, putting a statute on the books, and the rules for an initiative, putting a constitution on the books, are roughly the same, whether it's signature requirements or 51% approval at the ballot. Why would an interest group not always amend the Constitution under those circumstances? So one thing that I think would be quite helpful going forward is separate both. Make the signature gathering a little more burdensome when it comes to amending the Constitution. And I really would love to see, say a 55% vote for amending the Constitution, and fine 51% vote for referenda, or make it 55 referenda, 60. I mean, it's hard to take power from the people, as most people in government will tell you, but it doesn't seem to me that big a thing to leave 51% for referenda, 55 say for constitutions. So that's what I have to say. And thanks again for inviting me. It's great to be here.
We got some time for questions while we get lunch pulled up here.
This is more of a point for Judge Sutton, but since we're in Nebraska, you mentioned federal checks on the initiative process. And probably the major initiative in Nebraska in the 1980s was called Initiative 300. It restricted the ability of corporations to farm. It was referred to as a corporate farm ban, but it allowed family farms in Nebraska to exist under that. And that law initially survived a number of substantive constitutional challenges, both in state and federal court, but in the 2000s was invalidated under the Dormant Commerce Clause. So I think when we think about the Commerce Clause, we could also think about the Dormant Commerce Clause, and there may be ways in which some initiatives can be checked even without action by Congress.
It's a great point. We talked about this last night at dinner, this exact topic, and most of you here have already heard me talk about analogizing coin flipping to substantive due process, and coin flipping being superior as a way of deciding constitutional rights and inventing them. I don't think that much differently about the Dormant Commerce Clause would be my view. But the main explanation being nothing prohibits Congress in that exact situation from coming in and saying you can't do this. So it's just, and in a world in which Congress has trouble acting, of course, people are going to go to the courts. I think a lot of judges and a lot of citizens think that's healthy. They think it's good. Congress is dysfunctional. They can't get anything done. Who else to do it? The federal judges will do it. And, I guess I get that in the abstract, but it seems like it should not be a way of doing business, generally speaking.
Miriam, do you have a question? Miriam, do you have a question?
I do, yeah. So thank you both to these two panelists and the prior panelists. I learned a lot from all of you. I guess I was wondering if both Judge Sutton and Anthony might reflect a little bit for us on the types of procedural mechanisms that you both referred to for approving the drafting of an initiative. Seems like there's a range of approaches in states, some of which might supplement or even substitute for the underlying goals of the single subject rule. And then I guess there's the possibility that they could be misused, right? Like Judge Sutton, I think you spoke, pretty favorably about the idea of an executive branch actor giving sort of neutral feedback on whether something is clear. But Anthony, I wasn't sure I caught the full details of the AG notation that now has to appear on initiatives, and whether that is sort of an overstep of the executive role in the process. John Matsutaka, who writes a lot about initiatives and referenda, says the best practice is to just have the drafting done by a neutral entity, period. Maybe that is in some tension with the sort of, popular nature of the process. But anyway, I would love, both of your thoughts on sort of what would be the best system, and then maybe the pitfalls of different approaches as well.
Anthony, why don't you go first?
Well, it invites a war story from state government. I was the lawyer who would have to do the first draft of those on our initiatives, which I always enjoyed, because whenever I was coming out of the grocery store and someone came up to me with a petition, I was like, sorry, I'm conflicted. I can't talk to you about that initiative. I'd always have an excuse. But we'd work through it, and in Montana, it was the Attorney General who would do it, and we'd spend quite a bit of time wordsmithing, and you get proposals from the proponents, you get proposals from the opponents. You'd send it out to everyone to get kind of almost a notice and comment style process, and it would often take more of the Attorney General's time than they wanted to spend on it. One time on election day, the Attorney General calls me in and says, Anthony, I just voted, and it was good to see our initiatives, on there, and the summary statements. Some of the summary statements were there, but you'd also there's a 100-word summary statement. And he said, I looked, and all that stuff we wrote wasn't on my ballot. And what had happened was that the state or the county clerks and recorders had gotten a bill passed to save on paper and ink, to omit the 100-word summaries, so people could only vote based on the 25-word for and against. And so we went to the legislature and got that fixed. But I actually appreciate. I think Judge Sutton's right in terms of this is one area where kind of everyone has a hand in it, and that's probably the right way. Ideally, you could have a neutral party doing it, but there's a question about how you arrange that. Instead, the process in a lot of states seems to be the Secretary of State does some form review, the Attorney General does some substance review, the statements get drafted, and then the statements are judicially reviewable oftentimes before the petitions hit the street. And that might be an area where a confluence of various interests, as Judge Sutton suggested, from various parties with different perspectives, all meet with judicial review at the end to see whether it's plain language. And I'm not sure that's a bad way of doing it. It's certainly better, I think, than letting the proponent say whatever they want. Although as soon as we passed our law, then proponents started putting whereas clauses to write their own statements of purpose on the petition. But that seemed to work pretty well. And that's how it worked for us, at least.
Yeah, Miriam, maybe my comfort level with that process, it's very anecdotal, and it's not even as experience-based as Anthony's, so I'd be skeptical of it. So I'm just I was listening to him, trying to think why I think this has been working fairly well, even though sometimes government can be quite dysfunctional with elected officials and competing ambitions. One possibility is, I think it's really highly regulated. So, AGs have a role in doing these formal AG opinions. The agencies, usually the Secretary of State, will have written quite a bit, and they will have done this. These are old opinions and old rules. So they would have done it before, we knew the drama facing the initiative on the table. So it might be that my comfort level comes from the fact they're pretty boxed in. There's just not a lot of discretion. And then the only other thing I would say is it's really public. So if you were going to really play games, it's a little bit like Secretaries of State playing games right before elections. It's very, very public. And it has the real risk to backfire, because it's often quite apparent whom you're favoring, whether it's a political party in an election or the proponents or opponents of an initiative. So it's not to say someone wouldn't go all in and trying to undermine something, but it'll be a very public event, and that can be risky for politicians.
And thank you both for two incredible presentations. So first, I have a couple of comments and then some questions. One on Judge Sutton's point about how courts might be willing to use the single subject rule as a way of avoiding a direct conflict on the kind of a harder issue. As Judge Sutton knows, I've been doing a lot of work on state local preemption, and there were at least two major situations in which there were preemption conflicts, one on guns and one on minimum wage. Local gun regulation in Pennsylvania, and I think it was St. Louis raising the minimum wage, where in the states preempted in both cases, the state Supreme Court struck this preemptive legislation down on single subject grounds because the preemptive matter was kind of tucked into something unrelated. In one case, so they avoided the direct question of state or local powers in these areas. In one case, it worked for the local government. The legislature never got back to it, maybe because I think there was a change in the governorship. And in the other case, a year later, the legislature just did it all over again, and this time it prevailed. So there may be something, I'm not quite sure what that means in terms of what it tells us. Also, just in terms of the kind of the litany of potential constraints on regulation of initiatives, there are some First Amendment arguments. I don't know that they've gotten very far. I think they do affect questions about limiting. It was mentioned in terms of, I think Anthony raised this, the badges and the who can carry petitions, but I think there have been stronger arguments raised. I don't think they've prevailed, that limiting the ability to present an initiative is itself a First Amendment problem. And it goes into this sort of the double nature of what relating to what the initiative is. Anthony goes very hard on the powers, but another way to think about it is it's a way of surfacing issues for public debate. And so I think the First Amendment argument in this area has not prevailed, but I think it has been mounted, at least at the Court of Appeals level, in a number of areas, is to say that certain constraints that make it harder to get an initiative to the voters improperly interferes with the ability to get the issues aired and therefore interfere with public debate. I also just want to say I thought that the idea about analogizing this to the federal executive was brilliant. I think the idea that we have two legislatures is a great, and that much of this is about how to hold them together is terrific. I do want my general question, and there is a question in here, and it actually is inspired in part by Miriam's question, is taking this seriously as a lawmaking process. Direct democracy, I mean, there's a kind of a pro-direct democracy tenor. I'm not Judge Sutton so much as, but in the rest of us, I think, in this conference. And this relates, I think, John Dinan's point that kind of in terms of the politics of direct democracy has gone back and forth. And I think the very first thing I wrote as an academic was a book review of a book on direct democracy, which was concerned about direct democracy because of its impact on minority rights. This was the era of limits on open housing, attacks on affirmative action, and later became attacks on same-sex marriage. And so, but to make it more procedural, direct democracy has very few constraints. It doesn't have bicameralism in presentment. It doesn't have the deliberative process that is supposed to inform legislatures. And indeed, it's determined by the proponent. The proponent gets to write the proposal, maybe subject to some minimal constraints, but the proponent gets to set the agenda. And I do wonder whether that is something that justifies this lack of deliberation, the lack of vetting by anybody else in the political system, so that we really are ultimately relying on the voters. I kind of made the argument in favor of that a few minutes ago, but maybe I'm wrong. And maybe we do need, so there is a question. Do you think that given the lack of anything like bicameralism or presentment in this process, that some of these constraints that legislatures might put in or others might put in are actually appropriate to make up for the lack of the things that we normally look to in the legislative process: professionalization, deliberation, and the benefits of something being representative rather than direct.
Well, Richard, speaking for myself, you don't even need a question. You say so many interesting things. My mind always wants to respond to like, oh, this. You know, I meant to say this, so I'm so glad you raised this point. It's not the only way to think about it, but I did want to put this back on the table. Maybe we're understating the possibility of the Republican form of government guarantee. I heard this great presentation by Jason Mazzoni recently, where he pointed out that in Harlan's dissent in Plessy, everybody loves Harlan's dissent in Plessy, he relied on the Republican form of government guarantee. he was making the point that, how, when you have this kind of discrimination or a suppression of speech, just suppression of dissenting voices, it's not the government that we call American government. And so I think one way of thinking about your point of not having these Republican features of everything else but direct democracy, there's some good reasons to be skeptical of that. And so I hear you. It's a good point.
Yeah, quickly on the First Amendment piece and coming back to something that I hadn't picked up yet from Miriam's question. I do think so. For example, a law that says that if it's bad for business, you have to put it on the initiative. That strikes me as potentially a viewpoint discrimination issue, and we do have those backstops. It's not clear to me that I wouldn't be bullish on aggressive policing of this. I think Schuette is one example of this, and I don't think that's in the near term where we're going to be. The other piece on the bigger question on whether the initiative is better or as good or as close enough to the legislative process, I go back to my former professor Beth Garrett's view of hybrid democracy. And that's what we're dealing with. And I think the question we need to ask is, we've got sins of commission on the initiative process and sins of omission on a increasingly dysfunctional and non-majoritarian, as Miriam would say, state legislative process. Given that, the question is whether we work better with two dysfunctional institutions towards better outcomes or just the one. And I'm not sure I know the answer to that. I think it's probably worth revisiting some of the discussions of hybrid democracy, given the work that Miriam and many others have done on our democratic dysfunction at the state level too. But it seems to me that that's the question to ask rather than isolating the initiative process on its own.
One other thought. I was saying earlier how the initiative and constitutional amendment at the state level is really the same, except that one has to go through the legislature usually, and the initiative doesn't. So that's all that's going on, and you have to get your signatures. And the reason direct democracy is still appealing, even though there's so much similarity, is this fear that the legislature is going to block, because that's, of course, what you're trying to check. One possibility, you could borrow from quite a few state constitutional amendments have this, where if you're going to amend the Constitution, you need separate votes by different legislatures. So, it has to happen like 2 years in a row. I wonder if that's not a partial answer to your point, that an initiative, keep the legislature out of it, since that's the whole point, but you've got to have it passed by 51% vote over, a 2-year period twice. I wonder if that, I provoked John. Sorry.
We better grab lunch, so don't go professorish on this.
Real quick though, and so that's what Nevada is alone in doing that. Any initiated constitutional amendment in Nevada must be approved by voters in 2 consecutive sessions. There's a lot to be said for that Nevada approach, and some other states are considering that. So that has some foundation and could well be adopted.
I think we'll get started. So my idea with the last panel was for folks who are on the ground to actually tell us what was wrong with all of the stuff that's been said so far today. So Adam Moorfeld is on the far end. He's a state senator, very vocal. Is civic reform. What's the name of the group?
Civic Nebraska.
Civic Nebraska. I've got a sweatshirt for it. I was going to wear it today.
The work that I do on this stuff is mostly not related to that.
Yeah. So Adam will have insights, I think, from the legislative body as well as from the proponent's perspective to some extent. Andy Berry is an attorney here in town. He's got a long history of public service as well. He works at Klein Williams, and he's represented a number of proponents over the years and provided lots of advice on complying with the current slate of provisions that we have. In fact, shepherded the casino provisions through the process. Just this one time, or were you on at the times before?
I represented the Medicaid expansion.
Yeah, good. And Wayne Bennett is an Assistant Secretary of State, is that Deputy Secretary of State from Secretary of State's office. And of course, in our process, there is a lot of involvement with the Secretary of State in developing the ballot language, as well as determining, at least, I think, compliance with the single subject rule on the eve of placement. So I thought all three of them would have unique insights, and they could tell us where we went wrong, tell us things we haven't thought of, and provide us some insights. So take it away. If you want to entertain questions, we can do that. If you want to give a little talk and just move down the line, that's fine too, but it's up to you.
I actually had some questions for Adam and Wayne. Maybe to start with the reflection, I want to say as little as possible and learn as much as possible. One of the things that I think is interesting that isn't touched on in all of the doctrine is the pace of the process. You know, it has to be done within a very specific cycle. There's a certain amount of time that you have to gather signatures. There's a process at the beginning of even getting the language approved by the Secretary of State before the signature gathering process takes place. Then the signatures have to be gathered. And then the time between the deadline for submitting gathered signatures and then a final decision by the Secretary of State, possible appeal to the Nebraska Supreme Court, and printing of the ballots is extremely compressed. And part of what I think about as a practitioner is whether that process leaves enough time for good decision making, and what other alternatives there may be. And there may not be other alternatives, but I know Adam has worked with a number of ballot initiatives now more extensively than I at the introductory stages, and Wayne's in the thick of it when the challenges take place at the end. And I'm kind of curious what their reactions are just to the general question of time, and what the compressed time does to the process, and maybe, you know, the way that we look at these issues and the decisions that come from the Secretary of State's office and the Nebraska Supreme Court, or whatever court is having to decide these issues on a really compressed timetable.
I can go first. I didn't know Andy was going to be the moderator. I've got questions for him too. No, but I'm very happy to be here. Thanks for having us. And it's been really interesting. I was telling one of my colleagues out in the hallway that, it's interesting because I've been on kind of the running these ballot initiative side of it. I haven't taken a ton of time to step back and think about the theoretical side of it. And then also even just kind of the theories of democracy and direct representation. So it's been fun today. Now that I've stalled enough, I'll answer the question that Andy has posed. And, for me, it's a little bit of a trade-off, because as somebody who is collecting signatures or running operations to collect signatures, if we reduce the amount of time, in which we can collect the signatures and submit them, so that we have more time on the back end for judges and other individuals, administrators, executive branch agencies, to make more thoughtful decisions, or to have time to make those thoughtful decisions. We're reducing the amount of time that we have to collect the signatures. And we'd all like to say, well, you have about 1.5 years before the election to do it. That's enough time. Well, in any campaign, you'll know that it doesn't matter if you have 1.5 years or not. People don't start taking it seriously up until about 6 months to 9 months before. So every week before that first or second week of July deadline, it's kind of a moving target based on when the election day is. Every week is really valuable. And we've had some campaigns where we literally needed an extra day or two. We needed that last day or two. Otherwise, we would have been really in trouble and close to the qualification requirements. And so that being said, I will also say it is incredibly challenging to put together a brief to defend the legality of your initiative within just, what is it, sometimes a week or 2 weeks. Sometimes you can anticipate some of those things, but obviously you have to respond to some of the arguments as well. And so it's tough. I would say on a whole, we have got to have more time to be able, for one, the court to come to a decision. 3 or 4 days is not enough time for a court, in my opinion, to put together a really thoughtful decision. I'll just leave it at that. At the same time, we've got to maximize the amount of time in which we can collect signatures as well, because this is a really tough and complex process in many cases, particularly with the geographic requirements. 38, I think it's 38, I should know that, 38 counties that are required. So it's a little bit of a balance, but right now there is not enough time for the court system, for the attorneys, and then also I think for the Secretary of State's office to do what they need to do. And let's not forget all the local elected officials or election administrators that have to qualify and verify all the signatures.
So mark the date and time, Adam and I are going to agree on something. So actually we do more often than you would think. So even before I ran the election division for the Secretary of State, I was the election commissioner for Sarpy County, which is the 3rd largest county in the state, for 8 years before that. So I have the perspective of verifying the petitions, and now at the state level, they said it was a promotion and then COVID happened. And I'm like, okay, maybe I'm rethinking driving to Lincoln every day. I agree that the process is coming towards a breaking point. And we saw that in this past election, or in this past cycle. Even with COVID, we had 5. And that was the most we had ever seen in the modern era. And to do all those signatures takes a considerable amount of time. Now, Medicaid expansion in 2018, that was the only one. So we got it. We got everything out. We got it out to the clerks. And in 40 days, we had a decision. It was then litigated, but there was time for the district court as well as the Supreme Court to go through that process, because that 40 days was from the start. Because you have 40 days from when the clerk gets the petitions. Okay. So payday lending was first that came in. So they were before the deadline. So that was the first one that was worked on. Casinos came in next. 1, 2, 3. Marijuana came in 5th on the last day. So they were the last ones to be able to be verified. We spread it out so that 40 days, not all 5 of them, we had to process them, but we also spread it out of when we actually delivered it so there would be enough time to do it. Marijuana, unfortunately, was the last. So thus they were at the very end of the process, of which they got the least amount of time to go through a judicial examination. Whereas payday lending got sued, they actually went to the district court first, and then they went to the Supreme Court. So 5 was scary. It got us right to where I wanted to be, so there'd be enough time for a judicial review. And the judicial review happened the day, but we got the decision the day before I had to certify the ballot. And I still had to draw numbers because I didn't know what was going to be on or not on the ballot. And we had to draw the initiative numbers for that. And so, it came really close. And what I am worried about is what happens if there's more than 5? I have 12 right now that are in circulation, with another 8 to 10 maybe in the hopper right now at different stages. And that doesn't even mean more could come. At what point is this, to me, what keeps me up at night is not the single subject rule. It's the actual get the signatures done. Okay. Yeah, well, yeah, exactly. And I also get to say that, I don't have to, I love not having to sign a petition, because I conflict myself as well. So I worry about just the administration of it and what we can do. It's unfortunate. It's in statute of when the deadline is, 4 months before the 4 months before the election. So I have to change the Constitution to move that, or change how we verify signatures or what have you. So it's very difficult. My advice: get your petition in first. And you'll have the most time for a judicial review. So.
Wayne, I wanted to ask, so the 5 was in part attributable to the single subject rule because casinos was split into 3 because of a lot of litigation that we've had over casinos. How many of your current crop are split up because of the single subject rule, do you think, if any?
Is there 2 for you, marijuana? Yeah. So marijuana came back first with a constitutional amendment, but they have since refiled 2 initiatives for just law. Correct. Yeah. So far, that's the only one. And I guess I will take this time, since my boss was brought up on the casino issue, the right, good, bad, or indifferent of how you felt about his decision. His reasoning was if the constitutional amendment didn't survive single subject, there was no use of the voters voting for the other 2 because they'd be unconstitutional. So that's why the single subject, it was the constitutional issue, because there was a time earlier where casinos, some parts of the casino petition had passed, but not the constitutional amendment. So the legislature had to come in and repeal those laws that did pass by initiative as unconstitutional. So his mind was, and the court disagreed. He loves to say that his lawyer friends have told him that he was the only lawyer to be reversed by the Supreme Court twice in one day. But that was his rationale. Is no purpose of actually voting on the other 2 when the underlying constitutional amendment violated single subject, in his opinion. So
I have an even more powerful hand grenade to throw out right now, but I'm most of the fire would be directed at Adam, just as someone in the legislature, and maybe for yourself, but also just trying to think about other points of view in the legislature. So when I think about the timing issue and I think about the burdens that are imposed on the Secretary of State's office, I mean, we have a 19th century process when it comes to gathering signatures written in ink in specific geographic areas with a face-to-face requirement. You have to read the language of the petition out loud that has to be certified. Every page of signatures has to be notarized. That's not the way we do anything else in society or most other things. Why don't we switch this to a digital system of signature gathering? And if we did, what other types of adjustments would need to be made? What would the response to that be? There's a whole bunch of questions here. What would the response to that be in the legislature? And would we be raising all kinds of problems that have been discussed in the prior panels today about, I guess, imbalance of power between representative democracy and direct democracy?
Yeah, I mean, so on one hand, so first off, how that would fare in the legislature, it would not fare very well, I don't think. Just mainly, if you look at the demographic of the legislature, its average age is 60 plus years old. There's a lot of reticence to upgrading certain things with technology.
Let me stop you right there. Let's assume that those people in the legislature, are not going to be in the legislature 8 years from now. I mean, we're going to have a legislature where people are comfortable with all sorts of online transactions. Okay. So let's take that piece out of it.
Okay, yeah. I mean, we can assume that the legislature is going to be magically younger in 8 years, but we assume that, or they'll be more comfortable with technology. I mean, I think that there's a few different things. One, from a collection perspective, it makes it a lot easier. It makes it much more easier to deploy social media, grassroots types of campaigns. It makes it much more cost effective. One of the most expensive aspects of collecting signatures in Nebraska is the geographic requirement. On one hand, it also forces us to go out into communities across the state that maybe campaigns would not go to and connect with them and make the case. So, I mean, on one hand, it costs a lot more money. On the other hand, it forces campaigns to really go out into communities across the state and make the case, and then also identify supporters, which are very powerful to activate. And you know who they are because they're on your list and everything, to activate those folks when the election comes. So one, it would make it a lot cheaper, much more grassroots. Two, I think that it also provides opportunities for engagement in ways that you normally wouldn't. One of the biggest complaints that we get right now, so for those that don't know, I'm the co-chair of the Nebraskans for Medical Marijuana campaign. Right now, one of the complaints that we get is, hey, listen, why don't you have signature collectors out in my community in Alliance or Scotts Bluff? And it's like, well, we don't have volunteers yet because we don't have a paid operation yet. And so a lot of folks want to sign this, but they can't simply because the campaign doesn't have paid collectors yet. And so that really limits that person's access and ability to be able to be a part of that process. So bringing it online would help with that. Now, I'm an advocate for modernizing our elections. I'm an advocate for utilizing technology. I was pushing for online voter registration 10 years ago. We were able to get that passed eventually. That being said, I also have concerns about the security too. So we would have to come up with a system that that one is not only just convenient for folks, but two, that they can trust. And it's tough right now in our age of technology to come up with that type of system that people can trust. So, I mean, that's the other piece of it.
I guess what I would say with that, I think Senator Moranci had a bill 4 or 5 years ago to do that and never went anywhere. I would say is we have a model for it with online voter registration. The problem is you're going to need a driver's license or a state ID to be able to do that. So that's going to leave some people out of the process. So you're going to need, because we need to verify the signature. So you would need a hybrid process in which people that don't have access to or don't have a state ID or a driver's license, either to get one for free, then we're getting into another argument that let's just stop right there. That's another constitutional symposium. You'd have to have a hybrid model, either that or there could be paper available for those that did not have a state ID or driver's license. So from a verification standpoint, I think it would be a lot easier. And if we have one, no big deal. I found out 5 in COVID hit me hard. I don't know 6, 7 in a non-COVID year. Well, are we ever getting rid of COVID? I don't know. What is our breaking point? What happens when marijuana comes in 8th and I'm at the certification deadline and we're not even close to being able to do that? I'd like to be able to figure out what to do to make the verification faster. Electronic could do that.
In Nebraska, the signature threshold for statutory initiatives is 7%. And for constitutional initiatives, it's 10%. Do you think those numbers would make sense if you had online signature gathering?
I don't know how much. I don't know. I would have to look at the legislative history or perhaps the Constitutional Convention history on what the rationale was behind the 7 and 10%.
It's constitutional. Yeah.
I would have to look at the rationale of that because right now it feels somewhat arbitrary to me right now. So I guess the question is what is the point of the thresholds? If the point of the thresholds is to show that there's some kind of popular support for X initiative so that we can use it as a way to limit how many initiatives are on there, then if we make it digital, then I think there could be a case to be made that the threshold should be a little bit higher because you want to make it so that people can demonstrate that. It's tough though, because I say that and I'm not in support of more barriers. I'm actually in support of less barriers. I would say that it would still be challenging. It still would be challenging, even if you have a digital way of doing it. It would still be challenging to get to that 7% and that 10% threshold. The difference is it would just cost less money. Right now, it costs about $1.5 million to be able to get an initiative on the ballot if you're doing paid signature. Now, marijuana is a little bit different in the sense that there's a huge grassroots movement behind that, and we'll probably collect about 1/4 to 1/3 volunteer, right? So our costs will go down a little bit, but we also have 2 initiatives now due to the Supreme Court ruling on our previous initiative a year or 2 ago. And so I would say it would reduce our costs significantly, but it would still take a concerted and timely effort to get it on the ballot, even with the 7% and the 10% in my mind. I haven't answered your question, but I would not be in favor of changing the thresholds if we did get an electronic.
What's interesting to me is that when these thresholds and in the Constitution, everything's still the same. What's different? The population of Nebraska. And so I have to do, the verifying 10% in 18, whatever is a lot easier than verifying 1.2 million in 2022. So, do we grade on a curve? And so that's the problem is we have no more time for more work. So technology is supposed to make it easier. Maybe it's time to start looking at that, and there's other, you can do in the verification, like Colorado, they do a sampling, and that's been brought to my attention. I don't know if I like that. If you know what the sample size is, then you just make sure every 10th signature is good, while the other 9 are just made up. So, technology, I think would help, whereas everything else has not helped as the population has grown. So.
Other questions that anybody else has? Yeah. I've also got one more hand grenade to throw to Wayne, but you probably just want other people to ask questions.
Yeah, exactly. I'll give you some cover. No, I'm just curious. So some of the problem sounds like resources, and that it could be, the timing could be addressed if there was more resources. And so I'm just generally curious, which leads me to believe, is there a way you might describe the unicameral's feelings about the initiative as a collective, or is that not a fair question? Are resources for this sort of thing something that could be likely because there's a norm in favor of preserving the Nebraskan initiative within the unicameral, or is there? Because I guess as an outsider theorizing some of this stuff, I presume a tension between the two, but I don't necessarily sense the tension that I presume when I hear you all talking about it, as people responsible for monitoring it and enforcing it.
So when you say resources, are you talking about resources for the Secretary of State's office to be able to do the work?
Exactly. Like the legislature could fix some of those things, right? Like just to roll out more staff and resources. Am I wrong?
Considering it's on the county level, I've got counties of 300,000 and 400. Now, granted, the 400 county isn't going to need that many people, but you need, a computer, access to the voter registration system, our own security measures, what have you. Some counties will bring in temps, but there's only so many computers you can buy, so many people you can bring in to do this, and space that some of these people have. So there is some opportunity. One thing that I did work with the legislature, we didn't have the power to stop. We can stop at 105%, because I was worried the first one that comes, if we before had to verify every signature. And if we didn't have the opportunity to stop, then the first one that comes in, that's 8 million signature, 1.2 million signatures, 100% of the state, we would have to do that. I can stop at 105. But this thing that happens 3-4 months out of the year, it's going to hard to bring, you can't throw money at it. I need more time. And as the great Robert Downey Jr. said, not $1 can spend, but get a second of time back. So I need more time.
In terms of the legislature, I mean, what's interesting is if you look at the initiatives that have passed, and I wrote down a few of them here. Minimum wage passed in 2014. Medicaid expansion, which I helped lead, was in 2018. We had marijuana in 2020 that did not pass, as you all know. And then we also have casino gaming that passed, and there's been a myriad of a few different, and then we those were the ones I was mostly involved in. But in any case, most of them have been, I would say, progressive policy measures of some sort, right? Now we have voter ID out there right now, which I've been on the opposite side of, and because maybe my advocacy and others, people stopping in the legislature. Now it's going to the ballot, much like why I brought Medicaid expansion. I couldn't get it passed in the legislature, and so we brought it to the ballot. But most of these things have been progressive ballot initiatives. I have not seen a hostility to the initiative petition process in the legislature, even among those who have opposed these measures in the past. And they're pretty honest with me about how they feel about me or some of the other things. And so they would let me know. And mostly it's just, well, the people passed it. You know, I was opposed to casino gaming, but people decided to pass it, and we're going to implement rules and regs, or not rules and regs, but statutes to help support the rules and regs. Same thing with Medicaid expansion. The governor's office felt a little bit differently, dragged their feet for a few years, but people in the legislature, there's never been a talk about curbing the initiative petition process. I think maybe there was a bill a year or two ago, but it didn't really go anywhere, and it wasn't anything serious. And so, to answer your question, there is support for the initiative petition process. If funding was an issue, I think that they would allocate more funding to the counties or Secretary of State's office to be able to do that. But
I guess maybe I'll add from what Adam is saying is that right now we can get it done, and there isn't this talk. The first time I can't get a petition verified, there's going to be a conversation in the next legislative session. And so I'm trying to figure out where the breaking point is. And 5 came close. Maybe I can get a few more in, but that'll be a conversation. You know, right now I've got 12. If every one of them is going to make it, no, you know, because I don't think they have $1 million. But some people come in, file it. I think it's really easy to file one, and we'll have to do a lot of work to even get it on and then they never do anything with it. I also will say is that it's interesting what we've seen in the last 6-7 years is, you know, we're very with the unicameral, the second house is the people. Okay. And so the people's right of initiative is when they can't get it done in the legislature, the people do a petition. What we're seeing is, which is interesting, and this is no offense to you, Adam, or anything else, it's state senators not being able to get it done in the legislature. So then they go and do a petition process. Well, you have the opportunity as a state senator to be able to do it, but every one of these has either had a state senator as a sponsor or as a consultant, a former or a current, of everyone that's made the ballot. So I would like to be able to see the legislature maybe compromise, and that doesn't have to go to my side of the house. You know,
I got a few comments on that.
Yeah. You know, I've got a few more comments after he has comments, but I mean, the state senator is a person just like any individual who's not a state senator. But what I'm seeing is that stuff doesn't happen in the legislature. The same people that could pass it or not pass it are then going on the initiative side.
Well, and I'll say this too in response. I was going to say it before you even said that, is that one of the things that's interesting is I've talked to my colleagues and they go, well, why don't you just go try to put it on the ballot and see what happens? I'm not opposed to it. I won't be vocally in opposition. I might not sign it, might not vote for it. So it's almost like people are saying, listen, or people come up to me and they said, I would love to vote for that. I actually agree with you on that. I don't think my constituents do, so I'm going to vote against it. But I bet if you put this on the ballot, it'd probably pass. And so, you know, and I go, well, yeah, that's great. Do you have $1.5 million you want to give me? Like, you know, and so, so it's interesting. There hasn't really in our legislature yet been a hostility to the process, even on things that didn't even come close to passing. In the legislature. In fact, there's some legislators that are like, listen, you should just go to the ballot with this. I support you on it. I just can't support you publicly, but good luck at the ballot. And it's, you know, and so it's an interesting. Yeah.
Can I just make one quick question? I think in Ohio, they've had a couple situations. We have a pretty vigorous, enthusiastic initiative process. So I've seen situations where, whether they mean it or not, say, we're going to do an initiative. And the legislature says, well, we don't want that. We'll do something. Doesn't that happen some?
Property taxes, they've tried to, but they can't get the initiative. They can't get the $1 million. There's been a couple of property tax initiatives. They either haven't gone anywhere or they've stopped because there's been a compromise, but then the bill's never good enough. So they're always saying the next year we're going to do it again. So that's been the one. Yeah, that's the one that I've seen it threatened. I don't know if it's, you know, necessarily worked, but there, you know, it's being said right now, if we don't do something next session, there's going to be another property tax petition. And that seems to be a common running theme.
And one of the big things with the property tax issue is that yes, people are upset about their property taxes, but the ability to solve it on the ballot leads to, in a lot of people's minds, very undesirable outcomes, which is basically defunding a vast majority of government, and then what would be the funding mechanism to make up for that, or the consequences. So what happens is you don't get big money backers to back it, because the consequences of what could come next, if you take away $1 billion in revenue from local governments or whatever the case may be, it's too unpredictable. So anyway.
I just wanted to essentially agree with what you said, Adam. This was completely different in the 90s than it is today. And those initiatives were following up on things like Prop 13 and so forth, and generally would restrict government from doing all sorts of things. And the legislature did undertake some of their own initiatives, but also some of the restrictions on registered voters and the numbers and accounts and paid circulators and some of that stuff did happen. It did come about at that time. And so things are clearly different today, and I'm not arguing with you. I'm just, politics change, things go in cycles. And that's just an example of that.
I mean, what hasn't changed, though, which is interesting, is the process by which you collect these signatures. I mean, it literally is, and I've done this before, where I've spent a whole day collecting signatures. It is grassroots, and it is as direct democracy as you get it. And you have a lot of really interesting conversations with people one-on-one about these issues. So it's fascinating how the process hasn't really changed, even though the technology is out there. And I tell you what, managing circulator groups, I mean, it's like the Wild West too. And so I won't even get into that.
Yeah, I get those complaint calls too.
Yeah.
So.
I'm happy to talk to you during the cocktail hour.
Second favorite to yard sign placement. So that was my favorite call.
Anthony, do you have a question online?
Yeah, well, I guess first an observation that, and thank you for your service in various parts of state government. I've been there and understand the challenges. But one challenge it doesn't sound like you're facing is a challenge that election administrators generally are facing big time all over the place, is the concern about stolen elections and fraud. And it strikes me, having litigated signature fraud cases and it's a pretty messy process, and it's outsourced a lot, and it's there aren't as many controls as we might expect with a typical candidate election, and yet I guess I haven't seen too much of that, maybe because there's not the same partisanship there. Or are you actually seeing that? I guess I would take that as one good thing about direct democracy, that as messy as the process is, and as much room for error there might be on the margins, which keeps Secretary of State's offices up late at night, we haven't seen, I guess I haven't seen that bandied about as much as we've seen in other elections. Are you seeing it, or is this actually a bright spot in direct democracy, that people trust the system, even though it is actually far messier than candidate elections?
Okay, there was two different questions there: the initiative process and then the 2020 election. 2020 election, that's another symposium. I will say is there's always going to be a lawsuit for every initiative petition going forward, because that's the way it's just going to happen. Payday lending, the payday lenders thought they were going to be closed. They've sued, and there's always going to be one side, whether or not the Secretary of State rules in favor or not in favor. Medicaid expansion, Secretary Gale didn't touch it, but there was a lawsuit. So there's always going to be someone opposed to whatever they're doing. So once they hit it, it's going to go there. Now, in regards to the election itself, once it's on the ballot, yes, people have, we do have confidence in our elections. I am very happy to say we're one of the very few states that didn't have a lawsuit in any regards after the 2020 election. We were the only state to have a statewide primary with polling sites in May. So, I'm very proud of that, and no lawsuits in regards to anything of that process, except the placement of initiative ballots, which I just expect to have every year anyway. So once it's there, yes, it passes, people accept it. Then you go into whether or not how long it takes to implement. I know Medicaid expansion, there's been even the casinos, were passed a year ago. Regulations were just published yesterday. So, it just takes a while sometimes for some of this stuff to be implemented versus payday lending. The next day, payday lenders closed in the state of Nebraska after it was certified because they couldn't charge 12% anymore, or whatever the percentage was, and went down. So sometimes, things take a little bit longer. But yes, Nebraskans, on the most part, they are, except for the few phone calls we get every day, are satisfied with how we run the elections here. So
yeah, and I'll just say that I think largely people have confidence and trust in the initiative petition process, even though it quite frankly is a little bit of the Wild West and it's a little bit messy. I mean, you're trusting. We train all of our volunteers how to comply with the law. We tell them they must do this because if they don't do it, one, it could invalidate their signatures, and two, there are going to be people that are going to record what they're doing, and it could invalidate all of their signatures if there's recording that they're not reading the object statement or doing something like that. That being said, campaigns don't have some type of supervisor that is following every single collector as they go to their family reunion and pass out, the petition sheet. And we tell them, yes, you still have to read it to everybody. And so it's messy in the sense that it's very grassroots, but I will say that people have a lot of confidence in it. And there are checks and balances because all of these signatures go back to the 90 or so counties to have their individual signatures that are verified by the local election officials. So I do think it's a bright spot in our direct democracy.
Go ahead. If it makes you feel any better, my last hearing before I became an academic was Montana's payday lender challenge, a signature petition fraud challenge. So we prevailed.
I will say this, that one came the closest to, that almost got kicked off the ballot because they went canvassing and found a few people that they believe that they didn't sign, they claimed didn't do the object statement or what have you. So they found one county that was one over the 5%. But we had stopped at 105. So they had some signatures still that they didn't verify. So what they wanted to claim is that these 5 people got this county under 5%. Thus you only had 37, not 38. So thus you have to throw it off the ballot. Well, the judge didn't like the fact that these affidavits were coming after the fact, but that also my office verified the last 7 that never were verified, and they still would have been over anyway. So that came real close. And so I've had to start thinking about this 105% stopping, which I want to do so we can move on to the next one. But also some people are waiting for other counties to get done so they don't have to do the rest of theirs. So it's a balance. It's always been the joke. Everybody gets done except Douglas County, our largest Omaha, because they get the most. And so they also even kind of wait. I'm like, yeah, everybody else will get them done. So I don't have to do them, but they get the huge majority of them. But payday lending, that came dangerously close just because of the 38. So.
Okay, I think I know what my question is, but bear with me. So Senator Moorfeld, I heard you say that it's actually kind of great that you do get to travel across the state and go into these smaller counties or less populated counties to qualify things for the ballot. And my question is, though, if this is a direct democracy, a true direct democracy activity, and we are requiring 5% or 7% or whatever it is from a county that maybe you need 120 signatures, and then you're also requiring that same percentage amount for a county like Douglas, Sarpy, Lancaster, where it's tens of thousands. Are we not actually diluting the voices of those who live in urban locations and really magnifying the power significantly of less populated areas? And would it, well, maybe Senator Moorfeld, would you be open to this? But I'd be interested in both your perspectives on making it a statewide threshold instead of a county threshold, since it does seem to be, I've lost on this at the 8th Circuit, so I'll deal with that. But I would argue it's an unconstitutional violation of one person, one vote.
Yeah, I mean, I personally think that there's a very legitimate argument to be made that it's a violation of equal protection. And I remember the Eighth Circuit opinion a long time ago. I haven't read through it in a while. But yeah, I mean, you are treating similarly situated voters in a different way, based on the county size and population. And there's no doubt that campaigns are going to smaller counties to collect a smaller amount of numbers to hit that geographic requirement, because it's just easier to get 5% in a county with 400 people as opposed to 20,000 people. Now, depending on the subject, sometimes it isn't, depending on where you're at and things like that. I'll tell you with medical marijuana, it is. But in any case, yeah, I do think that that's a problem. I think on one hand, it forces you to get out throughout the state and really talk to smaller counties that otherwise would not get that level of attention. On the other hand, I think that there's legitimate constitutional equal protection problems. Do I see it changing? Probably not, because you would have to go and ask all these smaller counties to give up their power. And I think that that'd be a tough initiative an argument to make. I don't know how you'd make that in that county, but in any case, those are my thoughts on it.
I guess my recollection is the Eighth Circuit didn't talk about the 38. So I think that could be up for future consideration by a court. So I will say, if we don't have it, every petition will be in Douglas, Sarpy, and Lancaster County, period, because you can get it in those three counties. And so while you get the 38 in Western Nebraska, and actually you get the 30, some people get 5%, most people get 5% in Douglas, Lancaster, and Sarpy too. And so you get your numbers, you get your 125,000 in the big three, you get your 38 out west. And even in the big three, they're getting 5% because they're trying to crunch through the most population and the most signatures. I will say is if you go to all 93, the outcome is there'll be more challenges to signatures. And then if you find one county that is just under, then it'll invalidate the whole thing. So just thinking about that, just going through what I just went through on, we haven't had signature challenges here in Nebraska. You go to all 93, guarantee we're going to have signature challenges all day. So, and in 400, it might not be as hard in Arthur County. Actually, now McPherson's the smallest county after the census. So you might be able to find something in McPherson, and then it kicks the entire thing, and a lot of money and resources out the door. So I think it's a balance.
The constitutional text on the geographic distribution could be changed through a legislatively driven constitutional amendment. Would there be, that would look at the geographic distribution of legislative districts.
Now, if you're trying to get rid of the geographic distribution, I don't think that would ever have a chance of passing, simply because rural centers would not want to give up rural power in that sense. Now, if you're trying to expand it to the entire state, you might have a chance, but that's also going to make it much more costly and cost prohibitive to actually run some of these initiatives. So
there's only like 4 rural senators though, right? Seriously, couldn't Douglas, Sarpy, in Lancaster County with their representation say, we don't like the geographic distribution?
It could, but
they get a veto power out there.
And it would be filibustered then, and then you would need 33 instead of 25. So theoretically, you could get 25 urban senators now after redistricting on board. But I think it'd be tough.
Another question? Which judge was it, Battalion or Strong? You won on the one person, one vote. I think it was Battalion. Yeah.
Wayne actually invited me to throw my last hand grenade.
I'm here for it.
So this is my other question. It has to do with the relationship between courts and administrative agencies in the process, and on the single subject rule in particular. So I know the case is State Ex Rel Luncher versus Gale, which I think was a 2004, 2007 case. The Secretary of State's office in Nebraska at one point took the position that unless a petition blatantly violated the single subject rule, it would be placed on the ballot, and then it would be a live issue for litigation in the courts. But the Secretary of State's office was not going to really do heavy lifting to determine whether the single subject rule was met or not. In that case, the Nebraska Supreme Court said, no, there's an affirmative obligation by the Secretary of State to make that determination. in the first instance. And then there are a couple of different ways to get into the courts under the statute. There's a statutory way to go to district court, and there's the possibility of mandamus in the Nebraska Supreme Court to speed the process up, which is what happened 2 times last year. In 2018, when Medicaid was placed on the ballot, and there was no real challenge to the single subject rule, so the Secretary of State just placed it on the ballot, and then proceedings started in the district court there. But my question is, sorry, and it's all de novo review in the Nebraska Supreme Court. So how do you feel about the process of the Secretary of State making that initial determination on the merits to start the process off? Does it serve a valuable, take the law out of it, whether the Supreme Court was right in State Ex Rel Luncher versus Gale or not? Is that a valuable part of the process? And yeah, and let's just start there. Is it a valuable part of the process? And I guess, should the Secretary of State have, should the decision have more, should the discretion be more insulated on appeal to the Nebraska Supreme Court? What do you think about the policy issues there?
And we're out of time. That exact question is why we're all here today. Okay, so there were a lot of bills that came in the legislature in January that were going to change this review process, whether it be, there was a constitutional amendment to get rid of the single subject rule. There was like the Secretary of State and the Attorney General had to take a look at this. Just the Attorney General had to look at this. And so what the Secretary said is that, yes, this process is probably broken, but we need this to be able to figure out solutions. And then we can come back next year, to figure this out. Under statute, the Secretary of State can issue an opinion when there is a conflict, and it has the force of law unless overruled by a court. So when you have the opinion like he was asked to give in the casino case, then that's what was used to go to the courts. And then once he was asked that, I knew right off the bat someone was going to ask for an opinion on marijuana. They didn't ask for, no one asked for one on payday lending. We certified that, and then there were still lawsuits in regards to the language and other things going forward. So I think a part of this symposium and the papers and everything that we're doing is, how do we fix this process going forward? Does this happen before? Does this happen after? Does the Secretary of State play a role at all? And that's why we wanted to bring all these people together to figure it out. But I can't give you an opinion of what I think the office's position is going to be on, but we wanted to have this to be able to have that reasonable discussion. So.
If I can say one thing on that, I'll tell you that as a practitioner and user of the initiative process, we really got to figure out a way to be able to provide some type of guidance, given that the precedent on this is so muddled now. We've got to have some kind of guidance on what meets the muster in terms of the single subject rule and what is a valid initiative before we go out and start collecting it. Because I'll tell you what, we had on the medical marijuana side, that the initiative that got kicked off in 2020, we had people and volunteers literally dedicate 10, 15 hours a week for 2 years collecting signatures for this thing. And then, yes, we also had people with a lot of money donate money, and we had a lot of people with very little money donate money. And to do all of that work and then have it kicked off the ballot when there is just clear, overwhelming support for something like that on multiple different levels, I think is really unfair. And the thing that we should all be concerned about is it really breeds distrust in our process. I cannot tell you how many people now distrust the Supreme Court, distrust the administrative process in some cases, I think unfairly, because I think the administrative process was fair in that instance. I do. And I would tell, well, he did. But in terms of verification of the signatures and all of that, we did appreciate that. But in any case, I think that that's the thing that we should be most concerned about, is that when you have thousands of people in a state dedicating time, energy, and resources to something, and then they get all the signatures and make all the requirements, and then gets kicked off on what they view as a technicality that should have been resolved well before they did all that work. That's really breeding distrust in our democracy and in our process. And so I don't care what it looks like, but there has to be, I do care a little bit, but there has to be a way that we can get assurances that whatever we're circulating does pass constitutional muster, at least on its face.
And, you know, right now, in the all of this, there's only one instance in which the Secretary of State can strike it, is if it affects the revenue, affects the revenue. And so even we had to take a hard look at the property tax in 18. This was like my first month on the job, whether or not that one would do that. Then you make the argument, can you do it when, you know, a signatures, it's very easy to do a petition and then never collect any signatures. So is it not moot, but is it too premature to do anything that no one else is when you don't have the signatures? Even when you turn it in, maybe that's the time, because at that point you turn them in, we have to send it to the Attorney General for ballot language, regardless if it's on or off, because we have to get ready for it. So maybe at that point, but right now we don't have that structure, and hopefully maybe maybe that's what comes out of this.
And I know everybody's got to go here pretty soon. We're going over time, but the only thing I'll add to that is I also realize there has to be a little bit of a balance. You can't ask a court or some kind of body every single time, because it's pretty easy to submit an initiative petition. Yeah, it's pretty easy to submit that. There has to be some kind of threshold so that a court or administrative body isn't having to rule on every single initiative that gets proposed, because there are a ton of them, as Wayne just noted, that never have any legs and never were intended to have legs too.
You not only have to reject the state, but you then ask them to verify it's just one subject.
It's like signing an affidavit. I totally.